All right, welcome everyone. I'm going to call to order the meeting of the Sentencing Guidelines Commission. That's me. That's you. Okay. I'm going to go ahead and ask Nate to take the roll.
Thank you, Madam Chair. Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield. Crutchfield absent. Commissioner Fraze. Roll call, Commissioner Fraze. Fraze present. Commissioner Keefe. Keefe absent. Commissioner Knudsen. Knudsen absent. Commissioner Ladd.
Present.
Commissioner Ladd present. Commissioner Middlebrook.
Present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Moran. Commissioner Moran absent. Commissioner Mueller. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena.
Present.
Commissioner Saxena present. Chair Mitchell.
Present.
Chair Mitchell present. And Madam Chair, I think I am under the open meeting law required to get an auditory response. So I'm going to just ask Commissioner Fraze again. Are you present?
I am present.
Okay. Madam Chair, there are 9 members present, 4 members absent at this time.
Okay, and with that, we do have a quorum. We'll move on to approval of the draft meeting agenda. I would entertain a motion to approve the agenda. So moved. Commissioner Larkin makes the motion. Commissioner Middlebrook seconds. Any discussion on the agenda? Hearing none, let's go ahead and vote on that.
To the Larkin motion to adopt the meeting agenda. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Fraze?
Yes.
Fraze, yes. Keefe? Keefe absent. Just check on something, please. All right. Ladd?
Yes.
Ladd, yes. Knudsen? Knudsen absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the agenda is approved unanimously. Motion approved unanimously. Next item on the agenda is approval of draft meeting minutes from July 25th, 2024. You all should have had an opportunity to review those. It's my understanding there might be one correction. Is that correct?
Yep, Madam Chair, Commissioner Fraze brought to our attention on page 4 of the meeting minutes, under agenda item number 8, in the last sentence, there's a clause that says recidivism for drug and property crimes related to addition. The intent was addiction, so there's a missing C there.
I'm glad that you cannot be prosecuted for failing to add properly, so that's a good correction. So I would entertain a motion to approve the minutes with this correction.
So moved.
Commissioner Larkin makes the motion. Do we have a second? Commissioner Middlebrook seconds. Any discussion on the motion? Hearing none, we'll go ahead and vote on that, please.
To the Larkin motion to approve the July 25, 2024 meeting minutes as corrected. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Fraze?
Yes.
Fraze, yes. Keefe? Keefe absent. Knudsen? Knudsen absent. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, well, thank you, everyone. We have a lot to get through today. And just as a reminder, we did schedule the meeting to run till 4 this afternoon, anticipating that we would start to have more content in our meetings. We're going to start off with an overview, an agency supplemental budget request. And when you're ready, please go ahead and take that away, Nate.
Thank you, Madam Chair. All right, so in addition to your role as a policy setting body, looking, basically establishing sentencing guidelines for felony sentences throughout the state of Minnesota, you also have a second role, which is you are the oversight body for the state agency that also goes by the same name of Minnesota Sentencing Guidelines Commission, an agency that I am the executive director of. So it's in that role as the oversight body for the agency that I'm presenting to you my plan, my current plan for an agency supplemental budget request for the next biennium. The state is funded in 2-year budgetary periods called biennium, and the next biennium begins on July 1st, 2025, which is the beginning of fiscal year 2026. So it's fiscal years 2026 and 2027 that's the biennium that we're talking about. So we're funded through June 30th. We have $0 funded for July 1st at this time. That's really what the 2025 legislative session will be primarily focused on is funding state government for the next 2 years. And we do have some ideas for a supplemental budget request. So supplemental meaning above and beyond sort of the normal lights on budget request that would be ordinarily anticipated. This is the second time I've come to you with ideas for a supplemental budget request. The first time was last biennium. And the sort of highlight of that, well, maybe a highlight of that was funding phase 1 of the Sentencing Guidelines Comprehensive Review, which we're currently in. So before we get, and I'm not asking for a motion at this time. This is for your information. If you do have concerns, this would be a very appropriate time to let me know. But there's no specific requirement for you to adopt a particular resolution with respect to these budget items, but certainly as the oversight body, it's well within your power to let me know if you think I'm going in the wrong direction here. So before we begin, let me just present you with an overview of how the biennial budget timeline works. So mid-October, so the middle of next month is my deadline to ask the governor for supplemental funds. And that's, so that's why I'm presenting it to you now. If necessary, I could come back at the next commission meeting. I think it's a couple of days before the governor's deadline, but I'm at this point not necessarily intending to do that, just because it is so close to the deadline. What I need to do now, between now and then, is fill in all the numbers for these budget requests that I'm presenting to you today. November is the preliminary budget forecast. So the budget forecast is important because that establishes how much money the state has to work with, which is obviously a big factor. There's something else that happens in November 2024 that may or may not be relevant to budgeting in 2025, of course, and that's the election. Then after that, the governor prepares the budget request. That typically happens in December or January. And then in January of 2025, the legislative session begins. Then February of 2025, or sometimes it's March, there's a final budget forecast. And that's the actual budget forecast that the state, the legislature has to work with. Basically, that's when they're officially told how much money they have in the checkbook to spend, if any. And then hopefully by May of 2025, the legislature passes the budget for the next biennium. If they don't pass a budget for the next biennium, then we start going into potential shutdown mode. And then July of 2025, the new biennium begins, again, hopefully funded. So here's what we have for discussion, which is the tentative supplemental budget request. There's three areas under this supplemental budget request to talk about. One is temporary funding, and that's the Sentencing Guidelines Comprehensive Review Phase 2. Shouldn't come as a big surprise to you. When we introduced the Sentencing Guidelines Comprehensive Review, we introduced it as Phase 1. We didn't have a Phase 2 scheduled at that time because it was too early to tell where we'd be in the process. But we are looking at continuing the comprehensive review, so there needs to be funding for that. So that's where we get Phase 2 from. That's temporary. And then permanent requests are staff productivity improvements and maintaining current levels of service. So beginning with the comprehensive review Phase 2, again, all temporary funding. The first is research continuity. So we currently have research analyst intermediate Matt Kleina, who's been working closely with the University of Minnesota research team. He's actually going to be presenting to us today on some of the research that they've been doing. And the University of Minnesota research team is grant funded. That grant will run out near the beginning of the next biennium, but we're hoping that that by keeping Matt on as a research analyst intermediate, that he can that there can be some continuity with that research and continuing any additional research that the commission may need during Phase 2 of the comprehensive review. The second is another contract with MAD. Now, MAD is currently doing stakeholder engagement. We're going to be hearing from them on stakeholder engagement next month. And they're, as they continue to produce their reports to us, that'll be an ongoing thing. But they're doing stakeholder engagement right now. In Phase 2, there's really a different question, basically for MAD with respect to stakeholders. As I see it, the Phase 1 question is, what do you think of the sentencing guidelines? The Phase 2 question is, what do you think of these ideas that the Sentencing Guidelines Commission has for changing the sentencing guidelines? So a very different question, but it assumes, and I should say, I should have said this at the outset, we're sort of assuming / hoping that Phase 2 is the final phase. So we're hoping that the commission can come to some decisions in Phase 2 and start working on actually making changes, whatever changes the commission may see as being appropriate to the sentencing guidelines. So MAD's work on this would be sort of running those past stakeholders. Obviously, there'll be like a formal public hearing process in this whole thing, but this would be more of an informal and probably broader spectrum stakeholder engagement process, similar to what they're doing now, but just with a different research question. Drafting new guidelines language if necessary. So the idea is that we'd have a contract with the legal writer toward the end of this process. And also toward the end of the process would be technological preparation for the new guidelines policies. So we currently partner with the Department of Corrections Minute. Minute is Minnesota Information Technology. And so there's state employees who basically work for different agencies and charge them for that on IT projects. And we work with Department of Corrections on some small changes that need to be made from time to time to the electronic worksheet system. But we anticipate this being a bigger project and not the kind of thing that we could realistically expect the Department of Corrections IT staff to just do for free. So this would be something that we would expect funding for, and also general modernization to the electronic worksheet system. So the electronic worksheet system has not been significantly upgraded in over 10 years. And there's been a lot of advances, I think, in the IT world, and there are definitely some ways where we could make the electronic worksheet system more efficient, easier to use for probation officers who enter data into it, and hopefully free them up to do supervision of probationers rather than entering worksheet data. So that's the general monetization. But these would all be one-time expenditures. So moving on to the second area, which is staff productivity improvements. So we are looking at administrative staffing to free up personnel resources for research and customer support. And this would be a new permanent office and administrative specialist intermediate. We'd be asking for one full-time employee. It's possible we could get by with less than that, but at this point, we were advised by our fiscal staff, I guess you could say, the SMART helps us with our fiscal work, and they had a meeting with us last week about our supplemental budget request, and it was their recommendation that we ask for one full-time employee here, and I think it makes sense on a lot of that person could do things like, for example, run the meetings. Right now, we have a senior researcher running this meeting. It's not really an efficient use of her time, to be quite frank, and this is the kind of thing that would be well suited for an office and administrative specialist intermediate. And then we get to the third area, which is maintain current levels of service. So the maintaining current levels of service would be covering projected compensation deficits. So this is something we also learned from our SMART staff, our SMART, what we'd call them, but our SMART colleagues, I guess. I mean, we pay for their services to help us with human resources and budgeting. And they tell us that there are compensation deficits that are coming up, and those do need to be covered so we can pay our employees. So we're asking to cover projected compensation deficits. That's without hiring any additional people, just anticipated that we have deficits right now. Also, we're expecting some significant, we don't have the numbers on these, but expecting significant increases in minute charges to our agency. Also anticipating possible increases in the charges that the small agency resource team charges us, and possibly rent as well. So depending on how those numbers shake out, we'll also need to request supplemental funds for those. Finally, and the next two really had to do with sort of things that we've thrown off the ship in stormy weather and in the past, and we really need those back. So we do our researchers work on, most of them work on a product called SPSS, which is a statistical software package, and we dropped support for that. So basically we've been running for a number of years on unsupported software. We're not getting updates. We're not getting support for that. There are some risks associated with that, and so we're looking for funding to come back for that. We also dropped our Westlaw subscription, which is, we do some legal research. We'll talk about that in the later on in this meeting. And fortunately, our offices are close to the law library, so I have gone over there sometimes to do legal research. But it is, I think, beneficial to our agency to have Westlaw subscription back, and also funding for employee training and professional development. Another thing that's not been dropped, but significantly curtailed during past funding shortages. So that concludes the presentation. If there are any questions or comments, I'd be happy to entertain those now at this time, Madam Chair.
Any questions from commission members? Don't see any. What do you need from us?
Just any feedback you have. That's really all I need.
I mean, my feedback is all of this is necessary. And so I think you've done a nice job of putting it together. And I have seen some of this in the past, but I'm glad that you met with SMART, because it looks like you're taking care of some other pieces that maybe have gotten dropped. The budget has not rebounded since some earlier when the state was experiencing financial constraint. I think the budget hasn't rebounded from that point. It's time for it to, so that's good.
Yeah, and I'm not sure I'm at liberty to share like the minute cost increases, for example, but the numbers that were floated around are eye-popping. And our agency, I guess I didn't present this, but our agency has historically been and continues to be north of 90% is personnel compensation. So when we get something like that, we don't have a lot of fat, if we get a significant increase in non-compensation costs or compensation costs for that matter, we don't have a slush fund to dip into. We really don't have much we can go with. And you've seen some of the things that we've cut in the past. That's all we've got for FAT is basically, cutting off support for the main statistical software package that we use, for example. So, and cutting off our main legal research tools. So that's the kind of thing we've done in the past, and we don't really have much more of those kind of things to cut. So, it is necessary, unfortunately, for us to ask for supplemental funds.
Commissioner Mueller?
Yeah, my feedback is I appreciate that, some of the focus is on the employees and they're doing the work and the researchers and not just focus on the work of the commission, because as one of the newer members here, I see the value in what they're doing. So just in staff to support our researchers and some of the tech to support them or getting back on the support of the technology that they need, as well as the professional development and training. So we need the best of the best to help educate people like me. So thank you for focusing on that.
Thank you, Chief.
Great. Any other comments? Okay. Seeing none, we will move on to number 5, overview of criminal history. We have kind of talked about criminal history. I mean, we had a whole thing from Professor Fraze, but we haven't talked about what our policy is. So I think staff is just going to make sure we have a one-on-one on that.
Right, and this is, thank you, Madam Chair. So this presentation is really designed to kind of get us back to the basics here, assumes really very, very little information about the guidelines policy. And unlike some of our past presentations, which we've talked about sort of the why and the philosophy behind this, this is really just intended to be a presentation of the what and what is going on with criminal history in the sentencing guidelines. Having said that, so we're just going to be talking about what Minnesota's criminal history policy is, sort of a high-level overview. Having said that, I am going to jump in at first to a little bit of the why and very, very little bit of it. So this is a quote from the Commission's initial charter statute in 1978. I don't think it talked about grids. It didn't talk about cells. It didn't talk about ranges. It just had this very general guidance to the commission. Basically, give us guidelines and base those guidelines on reasonable offense and offender characteristics. So that's what it said. Reasonable. It didn't say anything about a grid. It said reasonable offense and offender characteristics. So the commission came back with this, which is a grid. And what I infer is that the reasonable offense characteristics are the vertical axis of the grid. So these different severity level rankings are basically the offense characteristics, and from the least severe offenses at 1 to the greatest severity offenses at 11, and then the offender characteristics are the criminal history score. So that's the horizontal axis, which goes from 0 to 6 or more. And the legislature didn't say it had to be a criminal history score. Just said reasonable offense characteristics, but that's what the commission came up with. So the criminal history score, as you can see here, goes from 0, well, it's a little bit small on the screen I'm looking at, but it goes from 0 to 6 or more. The grid does not go higher than 6 points. A few other things to note about the grid is that for more serious offenses, so these are the offenses at criminal history at severity level 8, 9, 10, and 11. And this is just the standard grid. There are 2 other grids, but they all follow the same, they all pretty much have the same structure, with one exception, and that's an offense that has a mandatory minimum on it. So it's all unshaded. But for the most part, the unshaded area is a presumptive commit to the Commissioner of Corrections. So as a result of that, because all those offenses above 8, 9, 10, and 11, we call those, they're above the disposition line. For those offenses, the criminal history score has only one function, and that is to increase the recommended prison time. But for the offenses below that, on 7, 6, 5, 4, 3, 2, 1, a higher criminal history score has 2 functions. It not only increases recommended prison time, but it changes the recommended prison disposition from stay to commit, unless the disposition was already a commit due to a mandatory minimum or other guidelines policy. Now, this is not a data presentation. This is a policy presentation. So I'm not intending to present a lot of data, but I do have one slide here. And that's when we start to talk about the 4 components of the criminal history score. There are 4 components of the criminal history score, but I don't want to mislead you into thinking that these are all 4 equal in practice. So that's why we have this one data slide. So if you were to take everybody's criminal history score in 2022 and add it all together, so this is like the criminal history score of everybody who was sentenced for a felony in Minnesota. The distribution would be that 87% of those points in the criminal history score would come from prior felony offenses. So prior felony offenses, big leader as far as contributing to the criminal history score of Minnesota defendants. In second place, and also second listed in the guidelines, is custody status points. So custody status at the time of the offense, that's 8.5%. And then misdemeanor points, so misdemeanors at the time of the offense are, oh, excuse me just a minute, I've got a little housekeeping to do. I think I'll have to take care of that later, but apparently we have a couple of commission members who are joining the meeting as attendees, but they should be able to hear what I'm saying. They just, unfortunately, I don't think I can elevate them to panelists without stopping the presentation. So should I just finish the presentation and then elevate them at the end? Okay.
Yeah.
So misdemeanor points comprise 4%, and then juvenile points less than 1%.
So just clarify, this is what do these percentage points mean again?
So if you were to add up all the criminal history points in 2022, so this is like, another way of saying it is, for an average defendant, 87% of the criminal history score is likely to come up from, be comprised of felony points. 8.5% would be custody status points, 4% misdemeanor points, and 0.5% juvenile points. So we don't see that many juvenile points, for example. So back to policy. So these are now we're looking at them all equally. These are the custody status. These are the 4 components, the possible components of a criminal history score: prior felonies, custody status at the time of the offense, prior misdemeanors and gross misdemeanors, and prior juvenile adjudications. And that's the guidelines order. I'm not going to take them in guidelines order because conceptually I view custody status at the time of the offense as being different from the others. The others all have to do with the prior adjudication or conviction of an offense prior to the time you're sentenced. And the custody status is really looking entirely at a different question, which is what kind of relationship did you have to the government with respect to supervising you when you committed the offense. So let's begin with prior felonies. So we're gonna look at 3 questions here. One is weight, one is decay, and one is prior. And we'll see some of these come up over and over again. You'll see decay in other circumstances. You'll see weight in other components as well. So the weight value varies by the prior felony severity, from 1/2 point for lowest severity to 2 points for the highest severity. This is not a feature that was true of the first sentencing guidelines. The first sentencing guidelines just gave every felony a 1 point weight. The commission decided that wasn't fair to treat a prior murder conviction the same as a prior bad check conviction, for example. So it weighted them differently. So you get 2 points for a murder and 1/2 point for the bad check. This is an example, I think, an illustration of sort of some tension that can exist in policymaking between complexity and fairness. I'm not saying that that fair policies can't be simple and that complex policies are necessarily fair, but sometimes there is some tension. So here the commission decided to make it a little more complex. So you've got a rounding factor. You've got to think about things like that. But that they decided that was worth it to make it more fair by having weight assigned to the prior felonies based on the severity. For sex offenses, there's some extra weight that's possible. And that extra weight is if both the current offense and the prior offenses are sex offenses or failure to register as a predatory offender, then there's going to be some extra weight possible for really severe prior sex offenses. Up to 3 points in weight is possible. The third point I want to note about weight is that expunged records still count. So sometimes there's a misconception about that, but in statute it says that expunged records may be used for sentencing, even though they're expunged and even though you may have a hard time finding them. If you can find them, they still can be used in sentencing. And the sentencing guidelines don't really take a position on that other than in a comment, the sentencing guidelines quote that statute that says that expunged records may be used for sentencing purposes. The second area to talk about under prior felonies is decay. And in order for a prior felony to count, to be basically relevant for the current sentencing, it can't be too old. And an offense is considered to have decayed if the prior felony sentencing date is more than 15 years from the new offense date. So if it's more than 15 years, it does not count anymore. And that starting point is either the sentencing date or if the defendant was ever sentenced to prison, then the release from prison date. So if either of those two dates, whichever one applies, must be within 15 years of the new offenses date. So sentence date to new offense date, and that's the decay factor. There is an exception if a defendant is still on paper, if you will, still in custody or being supervised for the prior felony on the new offense date, then the offense will not decay, even if it's been more than 15 years from sentencing. That offense will remain current up to the point where the defendant is discharged from supervision or released from prison. Well, if they're released from prison, then that starts the new 15-year clock. And then the third thing to talk about here under prior felonies is what is a prior? So, and this may be counterintuitive to you. An offense is considered a prior offense if it's sentenced before the current sentencing. So it's not looking at when the defendant committed the crime. It's looking at the sentencing, the moment that the judge is sentencing you for the current offense. The judge can look at any prior offense, any offense that was sentenced before the current offense is being sentenced. And that can even be on the same day. So it can be at the same hearing. So the judge is supposed to sentence defendants in the order in which the offenses were committed. But if multiple offenses are sentenced at the same hearing, assuming that's legal under the guidelines rules and under statute, then the second offense sentence will have the criminal history score included in it of the first offense. That will actually, so you'll end up, if you sentence many offenses at the same hearing, which we looked at a few years ago when we were studying child pornography, but we saw that was not uncommon, where you'd have defendants who would have maybe multiple child pornography collections or multiple acts of possessing or distributing child pornography, that those each one could add the criminal history score for the later one sentenced. So that you end up, even for a defendant who'd never been sentenced for a crime before, by the end of the hearing, the defendant's looking at a criminal history score of at the maximum of the grid because of the prior offenses that have been sentenced. And that accumulation of criminal history score at one hearing is colloquially called Hernandizing after the name of a court case. The next component is prior misdemeanors and gross misdemeanors. We have four items to talk about here, which qualify. So for misdemeanors, it's a pretty short list of targeted misdemeanors. These are offenses that the legislature says you have to be booked for. If you're convicted of one of these, or if you're charged with one of these offenses, you have to be booked. And the commission has taken that list and used it for a different purpose, saying that those are the misdemeanors that can potentially contribute to criminal history if you're convicted of those. On the gross misdemeanor level, all gross misdemeanors except for traffic offenses count. And an exception to traffic offenses has an exception to it. If it's a DWI or criminal vehicular operation, or it's an offense involving gross misdemeanor reckless driving, then it does count, even though it's a traffic offense. Also, what counts are felonies that result in a misdemeanor or gross misdemeanor sentence. So under the law, if a defendant sentences, if a judge sentences a defendant on a felony charge within gross misdemeanor limits, that offense becomes a gross misdemeanor. And the sentencing guidelines have chosen to say, well, since the law says that that's a gross misdemeanor, we will treat it as a gross misdemeanor. So it goes in the gross misdemeanor section of the criminal history score, even though it's actually a felony. Now, to confuse the matter a little bit, is the same law provides that a felony can also become a misdemeanor if a defendant receives a stay of imposition of sentence. So a stay of imposition means that the judge never pronounces the prison term, whether that's stayed or not. So an executed prison term can be executed, or it can be, the execution can be stayed. So the judge can say, I'm sentencing you to the Commissioner of Corrections for 36 months, but I'm staying execution for 5 years on the following 8 conditions. That would be a stay of execution because the judge pronounced the felony term. But if the judge never pronounces the felony term and says, I'm staying in position of sentence on the following, for 5 years on the following probationary conditions, then if the defendant completes probation, never has the felony sentence pronounced, then by law, at the time the defendant completes the probation, off in the future, it sort of magically becomes a misdemeanor, even though it had been a felony all the way through probation. The sentencing guidelines do not treat that offense as a misdemeanor, even though by law it is a misdemeanor once the defendant has completed probation. The sentencing guidelines still say that that offense can continue on in the felony section. That offense will continue on in the felony section. It does not get treated as a misdemeanor, even though by law it is a misdemeanor. And in commentary, the commission has said that's because, at least at that time, and I don't know what the current data are on this, but at least at that time, the commission was concerned about different jurisdictions using the stay of imposition, stay of execution tool differently, and was concerned about creating a disparity, maybe a geographical disparity. So it just said, we're going to just treat all of these stays of imposition as felonies. Second thing to talk about in misdemeanors is weight and limit. Each qualifying misdemeanor or gross misdemeanor is worth 1 unit, and 4 units are worth 1 point. So you might think that each one is worth a quarter point, but it really doesn't work out that way. Each one is worth nothing unless it has 3 fellows, and then it becomes worth 1 point. They all get counted as 1 point together. And there's a limit of 1 point normally, but there are exceptions for DWI or criminal vehicular operation, criminal vehicular homicide. If that's the current offense, then prior DWI's criminal vehicular operations are worth 2 units each, and there's no point limit. So instead of being worth 1 unit each, they're worth 2 units each, and instead of a limit of 1 point, there is no limit. So those priors can count. Now, we're going to talk about enhanceables in a minute, so that's going to kind of limit that to a little bit.
You're proving the point about why we need simpler guidelines.
It is complex, but it's fair, right? So that's the thing. It's a balance between fairness and complexity. Decay period is 10 years between the earlier sentence date and new offense date. So that's simple, at least. And then we get to enhancement. So if the new offense is a felony only because of a prior misdemeanor or gross misdemeanor, do not count the prior. Now this rule does not apply to prior felonies. And for subsequent felony DWI, never count the DWIs that first enhance the DWI to a felony. So that's a rule for basically under Minnesota law. If you ever had a felony DWI, and any DWI for the rest of your life will be a felony DWI. But you don't count the DWIs that first enhance that very first DWI to a felony. Those do not get counted for the subsequent felony DWIs. This rule is actually a little more complicated than it looks like on paper because let's say that you have an offense that's enhanced to a felony because of 2 prior qualified domestic violence related offenses. So if 2 of those are misdemeanors and 2 of them, let's say the defendant has 4 priors, so really double the number that he needed to get to the felony level. And 2 of those priors are misdemeanors and 2 of those priors are felonies. Well, we see here that the rule doesn't apply to prior felonies. So the prior felonies can count in criminal history. So do the prior misdemeanors also count? The guidelines honestly are a little confusing on that point. And there's some commentary that you can read differently from the guidelines itself. And kind of what we typically think of happening in the field is it's up to the prosecutor on what the prosecutor wants to claim is the basis for the enhancement. So if the prosecutor claims that the 2 felonies are the basis for enhancement, then at least under what we consider to be the prevailing interpretation, the misdemeanors can count in criminal history. But if the prosecutor claims the misdemeanors, then they don't count. Moving on. What's their questions? So prior juvenile adjudications, again, this is not a huge factor in Minnesota's criminal history score, but it does show up in the policy, so we're going to talk about it. So 2 prior felony juvenile adjudications are worth 1 point. The offenses must have been separate offenses or involve separate victims. For most offenses, there's a 1 point limit. So basically, you look at 2 juvenile adjudications. If they're felonies, you get a point. Except we're going to talk about timing in a minute. There is no limit, however, if the guidelines would have presumed imprisonment for those offenses if they had been committed by an adult. So, for example, offenses at severity level 8 and above, for those offenses, there's no limit. So you take 2 offenses that were below that and then add on all the offenses that were above that. There is something in Minnesota called EJJ, which is basically a situation where a defendant gets a juvenile sentence and an adult sentence at the same time. And the EJJ convictions are counted in the felony component. So they're counted, and they are considered to be felonies at the time. But, if they're satisfactory completion, they're not sentenced to prison. But those EJJ convictions are counted in the felony component, so they aren't subject to these limitations of the prior juvenile adjudications. The big limitation here is timing. So the defendant must have been at least 14 when committing the juvenile offenses, and the defendant must have been under age 25 when committing the new offense, the current offense. So that there's kind of a small window here where you're going to have prior juvenile adjudications. Older defendants are not going to see prior juvenile adjudications on their record. Finally, we get to custody status at the time of the offense, everybody's favorite component. I say that because the 2018 commission was really interested in custody status and made this policy. So the first question is custody. So this component looks at custody status on the date of the crime, as I said. So it's unlike the other components that way. Custody doesn't really mean custody. It can also mean probation, which is really the most common form of custody, and other post-conviction guilty plea statuses. And we're going to unpack sort of an odd exception to this later on in the meeting. If the criminal history score is 7 or more and includes a custody status component, the presumptive duration increases by 3 months. Weight and limits. So there's 1 point for most prior felony custody status. There's 2 points if the current offense and the custody offense are sex offenses. And there's a half point if the custody status offense was a low severity felony, targeted misdemeanor, or gross misdemeanor. Except that half custody status weight is on hold for now. And that's basically due to a drafting error that I made in 2019 when the commission created the half custody status point. I didn't realize at the time that the only rounding factor in the sentencing guidelines applied to felony points. So there's really no rounding mechanism for those half points, so that it's not really clear what to do with those. Finally, we get to waiver, which is another innovation in 2019 that the commission created. The district court may waive custody status on a case-by-case basis, applying guidelines considerations. But waiver is not permitted in certain cases, chiefly if the current or custody status offense is ranked at or above severity levels 8, H, or D8. Finally, just briefly to talk about consecutive sentencing. I'm not going to explain the rules on consecutive sentencing here, but there are some cases where the guidelines permit consecutive sentencing. Pretty much in a nutshell, it's if the current offense and the prior offense were both crimes against a person, per a list of those such crimes in the guidelines, then the court can sentence consecutively. But the presumptive disposition has to be committed to the Commissioner of Corrections. So in calculating that presumptive disposition, you do use the criminal history score, but in actually sentencing the defendant, you do not use the criminal history score. The other is presumptive consecutive sentencing, and that typically applies to defendants who are in prison or on escape from prison or in some kind of a custody, a pretty extreme custody situation. Then presumptive consecutive is permitted. So for permissive consecutive sentencing, the duration is calculated as if the criminal history score is 0. For presumptive consecutive sentencing, the duration is calculated as if the criminal history score is 1. I kind of think of that as sort of a consecutive, you still get the custody status point, sort of how I think of that. Anyway, that was probably more confusing than I even thought it would be. But, that's all I have on that. And now I'm going to get our new commission members in, our newly added commission members.
Let's give Nate a moment. We have a couple of commission members who are just located in the wrong place, so he's going to bring them into full participation. So think about whether you have questions, and when he's ready, I will call for questions.
Yes, so Commissioner Keefe is now in the meeting.
Right? Yeah.
If you wanted to welcome Commissioner Keefe.
Oh, is she up there now?
She should be. Amberthina Keefe, can you hear us?
Can you hear me?
Yes, we can. Thank you.
Commissioner Keefe, welcome to the commission. I know you were just recently appointed as a new member of the commission in the public member slot for individuals who are either victims of crime or advocates for crime. Would you mind saying hello and giving us a little bit of your background?
Sure. I'm very grateful and honored to be on this commission. My name is Amabini Keefe. I am currently the executive director at the Domestic Abuse Project. I am a clinical social worker by trade and have about 18 years of experience working with trauma survivors. So I'm really honored to be able to represent victim survivor voices. And I'm really excited about the direction of this commission and what that might mean for the community in the future. So thanks for having me.
Thank you so much. I'm sorry that your first meeting is a lot of detail about the criminal history score because nobody understands that. So
That's all right. I'm trying to keep up.
Welcome.
Thank you.
Any questions from members of the commission on the presentation we just had about criminal history?
There is a question. Let me see.
There's a question. I'm sorry. Oh, Chris, Commissioner Crutchfield.
Yes, can you hear me, Chair Mitchell?
Yes, we can hear you.
I was just wondering, Nate, do pardons act the same as expungements for the purposes of the criminal history score?
Pardons act the same as expungement.
Thank you, Madam Chair. Commissioner, no, they don't. A pardon is my understanding is a pardon is an expungement has to do with record keeping and where the conviction is held and who can see it and who has access to it. And I will say it's tricky to get expunged records even for sentencing purposes. I think there's an application process that you have to go to, but the law does say that eventually the prosecutor or whomever is interested in that record can get it for sentencing purposes. But expungement is a change in the legal status of that conviction. So it's an expungement is basically the equivalent as if an appellate court had thrown out a conviction. It's no longer a conviction at that point.
Being pardon.
I'm sorry, a pardon. I misspoke.
Yeah.
Yes, thank you. So
Director
yeah,
Bates, I knew what you meant. I thank you very much. Perfect. Thank you.
Any other questions? Commissioner Saxena?
I have a question, but it might be a longer question than we have time for. So I was curious about why, if there was some discussion among the commission as to why criminal history points are assigned based on the offense severity instead of the length of the sentence of the prior. So the federal sentencing guidelines impose criminal history points based on the length of the sentence, which obviously could vary based on the offender characteristics. Whereas in the state, it's based on the offense severity and doesn't matter how long the sentence was. Any reasoning behind that?
Commissioner Grace,
Looking
you look
over
like
here
you have an
also
answer.
to Commissioner Grace.
I don't remember, I'm sure that Dale Parent's book goes into that. I believe the federal approach is the only current guideline system that does it that way. And one reason they do it is because they are considering not just prior federal convictions, but state convictions, which you would then have to do what we do, but they'd have to do it more often, the translation. Well, what's this most like in our system? So instead, just go by the sentence. And, as you say, that lets you piggyback on and rely on the prior judge's assessment of how serious that particular offense was on the facts. But of course, that's also a source of disparity. So if you are unlucky enough to have had a really severe judge in this prior and another identical defendant that got in front of a very different judge, then they get different weights.
A great question, though. That's the kind of question that we need to be asking. Always don't question assumptions. So I'm really glad that you had that. You're bringing that view to what you're looking at here. Commissioner Larkin.
Just to make sure I understood it. So if someone gets a stay of imposition and they're successful, so they don't get the conviction or sentence, we still count it as a felony in the criminal history score.
Correct.
Any other questions? All right. Well, thank you, Nate, for providing that update. It's really useful background for many of the discussions that we're going to have going forward, like the next one, which is stay of adjudication as custody status. So I'm going to ask Nate to go ahead and move into that item.
Thank you, Madam Chair. So this, I hesitated to bring this to you because it basically will consume some valuable time that you should be spending on the comprehensive review of the sentencing guidelines, and I respect how much time that does take. But the reason I am bringing it to you is because I believe that it's a significant enough issue and it could have immediate consequences, and it really doesn't seem like it's a result that the commission ever intended. Before I begin, I just want to say that nothing I say is in any way intended to criticize or impugn the result of the Woolridge Carter decision, which one of the commission members contributed to. The decision makes sense to me, but the decision is a textual analysis of the sentencing guidelines, and I don't believe it's something. And while I can't really quarrel with the textual reading that the Supreme Court gave to the sentencing guidelines, I don't find that the commission ever intended for that result to be. In looking at the entire history of the sentencing guidelines, I don't think that the commission ever intended for the result in Woolridge Carter to be the case. And so that's why I want to bring it to the commission's attention, because being a textual analysis decision, if the commission disagrees with it, the commission can, without any disrespect, change the language of the sentencing guidelines and therefore abrogate the decision. And so what was the decision in Woolridge Carter? So defendant Woolridge Carter, and we do have a memo in your paper, I hope you get a chance to read that, but defendant Woolridge Carter was convicted of criminal sexual conduct in the first degree, which at a criminal history score of 0 carries 144 months of presumptive prison executed, and with a criminal history score of 1 carries 156 months of prison. So defendant Woolridge Carter's criminal history, he would have had a criminal history score of 0, except that he had a stay of adjudication. And this was a stay of adjudication for a property offense over $5,000 for theft. Now, A stay of adjudication is a process whereby the defendant pleads guilty, but the judge doesn't enter the guilty plea, doesn't enter a conviction. Instead places the defendant on probation. And if the defendant satisfactorily completes probation, there is no conviction. The defendant is never convicted of the crime. So we just talked about the criminal history components, and a stay of adjudication does not contribute to, in this case, a felony. It would not contribute to the felony component of the criminal history. It's not a prior felony because there is no conviction. And that wasn't the question in this case, whether the Woolridge Carter should have gotten a criminal history point for the prior felony, because there was no question that he was ever convicted of this offense. But the question was, should he get a custody status point for having been on probation for this custody, for the stay of adjudication? Now, historically, the guidelines have never come out and said that the defendant gets probation for custody status. In the beginning, as I put it in the paper, the custody status was for a conviction or for release pending sentencing. And then at one point, I think it was in 1987, the commission added a comment where it said that a particular type of disposition under chapter 152.18, which is for first-time drug possessors, that a defendant, that statute provides a statutory stay of adjudication process. And the commission said that will qualify for a custody status point, which was interesting because there wasn't really any language in the guidelines itself to support that. This was just something that the commission added to the commentary. And back then, the appellate courts actually gave more weight to the commentary than they give it now. They basically don't give the commentary any weight except as it might contribute to their understanding of the commission's intent. But they really rely on the language of the guidelines themselves. But the appellate courts did give that weight, but they limited it to 152.18 stays of adjudication. So they said, okay, we will give you a custody status point only for a stay of adjudication insofar as it occurred under chapter 152.18 for these first-time drug possessors, but we won't apply it to other stays of adjudication. For example, the stay of adjudication that Woolridge Carter got for the theft. And there was never any policy in which the Sentencing Guidelines Commission expanded stays of adjudication to non-152.18 offenses. Now, there were some policy changes at different points in time, and admittedly, some of those policy changes did result in confusing language, resulting in the language that ultimately the Supreme Court construed this summer in Woolridge Carter. But at no point was the purpose of the commission's action to expand stays of adjudication to cover all custody status, or all stays of adjudication to be included in custody status. In fact, in 2019, the commission repealed the language that had eventually been moved from the commentary into the guidelines that allowed for stays of adjudication for chapter 152.18. The commission repealed that language. And the reason they repealed it, because they didn't think it was fair that you get a custody status point for a stay of adjudication under 152.18, but you wouldn't get a custody status for, say, a stay of adjudication for a felony theft, as in Woolridge Carter's case. So they repealed it, and their intent in repealing it was clearly to get rid of all custody status for stays of adjudication. But unfortunately, due to some of the language that had developed over the years, there was language that basically made it possible for someone to read the guidelines to say, if you've entered a plea of guilty and you're put on probation, which was the case in Woolridge Carter's stay of adjudication, you get a custody status point. The concerns that staff has with the result in Woolridge Carter are, I guess the primary concern is sort of the idea that there's this policy that was created without any intent on the part of the commission. That this policy sort of evolved with some wording changes over time, but at no point did a meeting of the Sentencing Guidelines Commission occur, as far as I can tell, where a majority of the Sentencing Guidelines Commission said, yes, we think there should be custody status for a stay of adjudication. And yet that's where we are in the sentencing guidelines, which is a concern. I mean, the whole point of having sentencing guidelines commissions is that these commissions make intentional decisions about sentencing policy. But here's piece of sentencing policy that apparently just kind of grew up organically over time and was never an intentional decision of the commission. The second concern is a little bit more in the weeds, and that has to do with expungement. I said earlier that expungements can be used in sentencing, and that's true. As a general rule, expungements can be used in sentencing. However, in the last, I believe it was last year, the legislature created a special expungement law that's mostly about cannabis. But one of the provisions in that expungement law says that Chapter 152.18 dispositions that are satisfactorily completed are automatically to be expunged. So somebody who satisfactorily completes a 152.18 gets automatically, their record gets automatically expunged. And the thing about that particular statute is it has a language in there that says that other provision in the other statute that says that you can use expungements for sentencing, even though they've been expunged, that doesn't apply to this statute. So I think a reasonable reading of that is that you cannot use an expunged Chapter 152.18 for sentencing. Well, where are we right now? After Woolridge Carter, you can use a 152.18 for sentencing. And if the defendant was under a 152.18 probation at the time he committed the offense, but has been discharged and is now facing sentencing for another offense, and that offense was automatically expunged because he was discharged, you won't be able to access that record for sentencing, as far as I can tell, which means you're going to have defendants treated differently depending on whether they were, whether they got a 152.18 or not, and whether they've been discharged or not. So it does create some problems. So staff is inviting the commission to consider whether or not it wants to make a sentencing guidelines change. This would require a public hearing. Typically, we have these in December. The commission would have to take action sometime this fall. I know this is just the first time we're bringing it to you, but to get back to what commissions in the past have intended, we would recommend the language change that's in the back of your memo, where basically a conviction would be required for a custody status point. The only exceptions to that would be pretrial release and pretrial confinement. For pretrial release and pretrial confinement, a guilty plea or guilty verdict is sufficient. A conviction does not have to be entered quite yet. But for all other forms of custody status, they would have to follow a conviction. And that is what we understand the commission's historical intent to be. That's not to say that that is the current commission's intent. And obviously the commission can have a different policy now. But you know, again, sort of with our status quo bias to sort of restore the sentencing guidelines to the historical intent of the commission. That's the language that we're suggesting.
Thank you. Commissioner Larkin.
Just a quick question, because I'm sorry, I misunderstood. If a person gets a stay of imposition on a felony offense, successfully completes probation, that's not considered a conviction of a felony in the eyes of the law, but we do treat it as a felony in the criminal history point calculation.
So you're back to stays of imposition? No? You're talking about
Yes,
stays?
oh, okay. And so you're just talking.
So I'm just talking about stays of adjudication.
Okay.
So, yeah, for stay of imposition, you actually are convicted. And you are convicted of a felony for a time. But then at the end, you know, as if the blue fairy waved her magic wand, you become a misdemeanant instead of a felon once you complete probation.
For the stay of imposition.
For the stay of imposition. Stay of adjudication, you've never been convicted. There's no questionnaire that you would ever have to fill out that says I've been convicted of a felony. You did enter a guilty plea for a felony that, you know, can get you in trouble, I think, for immigration consequences and so forth. And you admitted in court that you committed the elements of the felony, but no judge ever entered adjudication of guilt on that, assuming you complete probation satisfactorily.
Questions, comments on this topic? Commissioner Larkin.
I think what Nate's proposing would make a lot of sense were we not in the middle of a comprehensive review of the guidelines. And I know I've shared this thought with Nate and Kelly. I mean, we're embarking on a 2-year review of the guidelines. And when we started this, we were told, everything's on the table. We're not bound to prior decisions by prior commissions. We can, come up with fresh ideas and put those into place. And this is a lot of work, a lot of time. And the commission staff has done a great job of presenting us with a lot of information. But I just feel like to take this one issue and say, well, we need to decide what to do with this issue now, even though we're going to look at everything over the course of the next year, including custody status, just to me seems counterintuitive. I don't know why we would do anything substantively now based on intent of prior commissions, and I have no reason to quarrel with what that intent was. But if we're bound by intent of prior commissioners who are no longer here, why are we doing a comprehensive review? The timing of this is awful. The timing is awful. But I mean, I've been on the commission a few years. We've been dealing with custody status. We worked on it for 2 years, couldn't come to a resolution having to do with that half point issue. And so at that point, I think we all just said, we're going to table it. We'll deal with it as part of the comprehensive review. So we're going to have conversations about custody status. Should we use custody points at all? If so, for whom? Certain offenses, all offenses, treat all the same. I mean, there are so many issues related to custody point. It seems, again, like I say, counterintuitive to say we're going to take this one issue and decide it now after just talking about custody status for the first time. I mean, we've had lectures on criminal history. What does that mean? We're hearing today for the first time, many of us, not me, obviously, although it might appear from it for my question, how does all this work? I just don't know that we're in a position to tackle the substantive question that's been raised by this decision. And I think the more prudent approach would be to just postpone a decision on it until we get to the custody point part of our comprehensive review and deal with it with all the other aspects. I know one thing the chair has always said is, every lever you pull on the guidelines impacts something else. So we have to be mindful of like what seems like an innocent little change might have ramifications. And that's what we saw with, the half point issue. And, it was a mistake. It happens, but I think you make mistakes when you move too quickly just for the sake of moving quickly. And I appreciate that there could be some impact on some people between now and our resolution of this, but I just don't think it's solid decision-making to pull this one piece out and devote the time and energy that's necessary to resolving this one issue, because it seems like a simple issue, but with everything else, people will say, well, what about this? How does it impact that? And one of the things that held us back last time was there was a lot of public opposition about the notion of eliminating custody status as a consideration at sentencing. And I don't know if that public sentiment has changed. And if that comes forth, is that going to throw a wrench into it? And as someone who's been in this process, I know how time consuming it is. And I would hate to see us go off on this path and take away from, what we've tried to schedule in for a comprehensive review with limited time and limited dollars. So, I mean, to the extent that anybody is looking for a motion on anything, I think the motion I would make is to postpone until such time as we get to the custody status portion of our comprehensive review, rather than dealing with this single aspect of that process now this fall, because I don't think we're in a position to tackle it now.
Are you making that motion?
I would make the motion. As I understand it, it does require a second.
I'll second it. Okay, so we have a motion by Commissioner Larkin, second by Commissioner Ladd to postpone addressing this issue until we take up the custody status portion of the
Point of order.
criminal history score. Then it's open for discussion. What's your point of order?
Is such a motion a sort of a non-debatable Because it does cut off any further discussion.
It doesn't
No,
cut off
no,
our
it
debate.
just puts the motion, puts the topic on the table for discussion. So the next step now is people can
Why
raise
don't
whatever
we
they want.
discussion of the motion? I mean, questions or comments on the presentation that was just made?
It doesn't cut off that either.
Okay.
Okay, so I want, I do want to, well, open it up for discussion. People can start to raise their hands. I actually want to go first. I just want to say, number one, I do think that the Minnesota criminal sentencing guidelines are rooted in being based on convicted behavior. Unlike the federal sentencing guidelines, we do not sentence based on behavior that has never been convicted. They work off of a different standard. And that was a really fundamental philosophical discussion that the commission had at the creation of the sentencing guidelines. And so I do think that the problem for me with the Supreme Court's decision is that it takes us away from that route and allows unconvicted behavior to now become something that adds to the criminal history score and affects the sentence of an individual. So for that reason, I think this is really a corrective action. I think we do need to address it more quickly than the review will allow us to. I really think I totally agree that we shouldn't do this very often, but my concern is that the guidelines that are in effect in the year that you commit the offense are the guidelines that are going to affect that sentence. So the shorter we can make that period of time, the better, if we're going to continue with our philosophical position that only convicted behavior should result in a sentence. So that's really one of the keys for me. I will be voting against this motion, but I also would want staff to bring forward, because we do have a policy that does not allow us to approve a language change at the first meeting that it comes up. So we won't be doing that today, even if this motion, like if this motion fails, we wouldn't go next to approving that language. We have one more meeting at least that we would have to take it up. But I would, if we go to another meeting on this, I would like to see some impact. Like, could we estimate sort of how many sentences might be affected by this change in policy that the Supreme Court has sort of imposed on the guidelines? So I would want more information to be brought to the table before we would make a final decision on this. I would rather we even do that before we go to the point of deciding not to do it. So my position today would be to vote against this motion because I don't want us to, because we're not going to take any, I think we shouldn't take any decisive action today, but we should instead get some more information before we make a decision on this one. And with that, I would open it up for other people to also comment or ask questions. Commissioner Middlebrook?
Thank you, Madam
Commissioner
Chair.
Sexton.
Having been on the commission back in 2019, when it was a unanimous decision at that time that the stays of adjudication did not count in the custody status for any stays of adjudication, that was when they repealed the 152.18. And that was unanimous. The whole commission agreed that those should not be counted. I understand, having been involved in this case of State versus Woolridge Carter, I understand the Supreme Court, that wasn't a unanimous decision either. There were two dissenters. That they took a strict reading of what probation meant. And so I think that I see it the same as the chair, that this is a corrective matter. We're not changing what the intent of the commission has been all along, particularly since 2019. And also, I think I agree that we can get some more information. I did see the memorandum that there's quite a few cases that this is affecting. And it may not seem like that many when you put it in the percentage, but the number of cases that are getting increased sentences because of this decision is quite a few. And that's a short little time period.
Commissioner Saxena.
I just wanted to add, I appreciate the comments from everyone. I actually viewed it as the amount of time that it will take us to do the comprehensive review is actually a reason to address this corrective action now. It seems like the issue has been pretty well laid out for us. There's not much to disagree with here, in my view. The issues at hand have been laid out quite clearly. And it's going to take us so long to do this comprehensive review that I don't see any reason why we couldn't, if the majority of commissioners agree to this corrective change now, we couldn't then deal with any collateral consequences of it later or change it again if that is what is necessary through the comprehensive review. So given how much effort is going to go into that, I actually think we should handle this low-hanging fruit immediately, as opposed to waiting for that much more complex process to play out.
Commissioner Reeves.
Thank you. I just wanted to say I do agree that we need to get more information, but I would also like to address this as soon as possible. As we start to clear the backlog, going through probation cases as they continue to do so, this is an issue that needs to be resolved in some capacity. So I appreciate the Commissioner Larkin's comments, but I do think since we are doing the comprehensive review, this is one that directly affects the work that I and many other agents in the state do. And so I would like to see us take some action on this, whether we have an order that we do so. I would like to do it sooner rather than later, but I will be voting no on this motion. Thank you.
Thank you. Any other comments or? All right. I'm not seeing any other comments, so I think we'll go ahead and vote on the motion.
To the Larkin motion to postpone addressing the issue of a stay of adjudication as custody status until the commission takes up custody status later in the comprehensive review. Larkin?
Yes.
Larkin, yes. Crutchfield?
No.
Crutchfield, no. Fraze?
No.
Fraze, no. Keefe?
Abstain?
Did you say abstain?
Yes.
Okay, Keefe abstains. Knudsen? Knudsen absent. Ladd?
Yes.
Ladd, yes. Middlebrook?
No.
Middlebrook, no. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
No.
Reeves, no. Saxena?
No.
Saxena, no. Chair Mitchell?
No.
Chair Mitchell, no. Madam Chair, there are 4 votes in favor, 6 votes opposed.
Okay, and with that, the vote, the motion fails. Any other comments on this? Commissioner Fraze.
It's really more of a clarification. I assume, if I'm understanding the way this is set up at sentencing, and more broadly, somebody who commits a new offense while they're on one of these stay of adjudications, even if they don't get a custody status point, they're probably, if the case can still be prosecuted, I mean, there's a guilt. So I guess they'll go ahead and activate that and get a conviction for that prior crime. Is that right?
They could.
I mean, it
It's
seems,
possible.
especially if there's no custody status point. Now, it cuts both ways, because maybe the defendant would rather have a custody status point than a prosecution. But it just, it does raise the broader issue, which we will have to look at, of custody status versus all the other things that can happen to a person because of the custody status, besides the custody status, or may not happen, depending on how the parties say maybe you guys want to have.
Commissioner Larkin.
Can I ask a question on the concept of we don't consider anything unless it resulted in a conviction in sentencing? How do we reconcile that with our use of a point for juvenile offenses? Not EJJ offenses, but delinquency offenses, because delinquency offenses do not result in convictions, and yet they result in a custody point.
The disposition, I mean, it's a good question for us to talk about. I mean, I think that's actually a great question. My guess would be it is a completed disposition, at least. It's not a something less.
But we
than
just
that.
have to be careful when
Yeah.
we say things like, well, we don't do anything unless there's been a conviction, when we have a rule that says we treat 2 juvenile adjudications as felony custody point, depending on the crime, the age of the offender, and the date of offense.
Commissioner Middlebrooke.
Just, Madam Chair, just to clarify, I think you're mixing up the criminal history prior conviction points with the custody points. I don't think the juveniles count as custody.
They don't, but broad statements have been made that everything's based on a conviction when it comes to the sentencing guidelines. I'm just pointing out that there might be some inconsistency in that policy. And I appreciate it because it counts in the criminal history point.
Commissioner Mueller.
Just a little clarification. I'm grateful for everyone's, all the experts in the room and your discussion, because I continue to learn from that. Just clarification for me. So the custody points for a 152.18, now that is gone. That's been addressed by a previous commission. There's no custody points. Am I correct in saying that?
Correct.
I think it's back though. After Woolwich Carter, I would assume it's back.
Okay, potential. Okay, correct or understood. And then expungements, there's still custody points for that, correct?
Well, I think if I'm not an expert on expungement law, Madam Chair, if I may, but I think in order to be expunged, you have to be off supervision. So I don't think you would. So no, I guess that's not true. So I guess if you were on supervision at the time you committed the offense and then it were expunged, then there's that question of whether you could find the record and prove that you were on supervision at the time.
I think you're just asking in general, an offense
Well,
that has
from
been expunged.
Yeah, from the explanation that was gone through on the not the memorandum, but the paper, they said some notes on some things that I heard. I was just trying to get some clarification from that.
There's another law that says whether or not an expunged record can be used for sentencing purposes. So if that law applies to that expunged offense, then it can be used for sentencing purposes. What I heard Nate say is that there's a law that deals with those cannabis expungements that takes those out of that pot of prior expunged offenses that can be used for sentencing purposes.
Thank you.
So it's very complex and it takes
Appreciate
a
that.
lawyer
Thank you.
to figure it out.
I know I should have gone to law school.
No.
Takes an expungement lawyer, not the rest of us. Commissioner Ladd.
Thank you. And so I just want to, I wasn't going to just repeat what Judge Larkin said, because I felt like she lived the custody status point debate and discussion that we had previously, because I do think there's a lot of tentacles to it. And I think that a decision on this carved out exception to custody status might be dispositive of the whole. And I get the timing is horrible, and that's nobody's fault. It's just plumped in front of us. And I think some complicating factors here are, when we're talking about statutory states of adjudication under 152.18, that's completely different than the ones where the prosecutor has to agree, because there's some law around that too. And then there's been some reach on 152.18. They only used to apply to 5th degrees. Now they apply all the way up to 3rd degrees. And that concept in terms of an intention of how that should play, because a 3rd degree a drug offense is very different than a 5th degree drug offense. So there were some changes. And again, we haven't sort of moved all at the same pace and at the same way. And I think the concern too about this, and again, time, effort, and energy, I worry about us, because it was a painful, robust process that we had before that just really kind of got us to where we started talking about this comprehensive review. But, when someone gets placed on a stay of adjudication and their sentence, they are pending sentencing, because they're stayed and suspended. It's deferred, and the court accepts the guilty plea, but they don't have a sentence. So it's just not unlike when somebody actually pleads guilty and then there's a sentencing date down the road. It's just a lot longer down the road if they don't do what they're supposed to do. And so I think in terms of the functionality of what our expectation is for that, the release pending sentencing kind of deal equivalent. And again, I think when we start making these exceptions, we start then creating other, like, well, what does that mean, how it applies this way? Because there are some nuances that I think sometimes we don't think about. So for that reason, I continue to want to wait so that we make a good decision as a whole, and so we don't create more work for us on other unintended issues. And so that's my concern, and I just wanted to say that. And I didn't necessarily want to repeat what Judge Larkin had previously said, but I do think that this takes a lot of oxygen sometimes from what we got to do, and we've lived that before, and so timing is not perfect, but that's my concern.
Commissioner Larkin.
Just on the substance of the issue, if we're going to tackle this now, I want to make sure we're not going into it with sort of blinders on. It's like, well, whatever it is, we determined the prior commission's intent was in 2019, and I get it was a unanimous vote. That doesn't necessarily mean that that's binding on us now. We have to consider all sides of the issue. I mean, for example, I didn't realize that on the third degree controlled substance crime. I mean, was that a permissive basis for a stay of adjudication when the prior commission voted unanimously to say stay adjudications don't count for custody status? If not, it seems like that's pretty, was it?
That was the, sorry, Madam Chair, I think that was from the Drug Reform Act. That was 2016.
Yeah.
I just want to make sure we're looking, people are able to come to the issue with a different view if they have a different view. I don't know what my view is, but I'm concerned sort of about the, well, it's just, here's what the intent was, so we just need to fix this so current guidelines reflect the intent when we're in the process of looking at everything. I mean, there is a body of case law that says in terms of revoking probation, if you were granted a dispositional downward departure, in other words, you committed offense for which the guidelines presumed you would be sent to prison, the judge found substantial and compelling reasons to do a downward departure and give you a chance on probation, and then you mess up on probation, one of the things the court is allowed to consider in denying ongoing probation is the fact that you were given this chance. I mean, so one person might look at this and say, well, you know, a person who's given a chance on probation and commits a new offense, they should have a custody point because they didn't get the message. Well, someone might argue that a person who is on a stay of adjudication has even more incentive to remain law-abiding because they're avoiding the possibility of a conviction and a sentence. So I don't know that everyone would necessarily say that shouldn't be a basis for a custody point. People might say we shouldn't have custody points. I just think it's such a huge issue. And we, you know, I appreciate Commissioner Ladd talking about sucking oxygen out of the air. And I just let the new members know that when we say we debated custody point, we did it for 2 years with 2 public hearings and then didn't have a resolution. So, I mean, I have that context in mind. But I just would like a commitment that if we're going to delve into this issue this fall, we're going to go past, well, what was the intent of the old commission? That's what we're doing now.
So in the interest of time, I do want to move us on, but that's a great point, because what I wanted to say to the commission members is we'll put this on next month as just as a introduction for new members. We, as I mentioned, we have a policy that if Director Wrights, if you haven't shared it, please do after this meeting. We have a policy that says if we are considering any changes to the guidelines, it has to come up at least 2 meetings before we take any vote on that language. So there is no option to vote for language changes today. So if there's additional information that people think would be relevant to that discussion, please let staff know that, or if you let them know that, because I think we have to move on. And so that we can pull that into the discussion for next time around. I think that's exactly what we need to be thinking about. And the delay is exactly, the whole purpose of the delay is so we can marinate on this and think about those things that you're just raising. So I think that is an excellent reason for that policy as well. So we will move on. We have a lot of other things on the agenda, so we'll move on to number 7, which is University of Minnesota Research Team presentation. Dr. Lesperensky is here from the U of M, so I'll turn it over to you.
Hey, hi everybody, how are you? Glad to be back. Let me go ahead and share my screen. Okay, can everybody see my presentation?
We can.
Great. Okay, so for those in the audience who may not know me, my name is Julia Laskrinsky. I am the research director at the Robina Institute at the University of Minnesota Law School. And we are part of the research team that is assisting the Minnesota Sentencing Guidelines Commission, that's you, with the comprehensive review. I wanted to give you an update, a research update on the increasing presumptive prison rate, which was one of the big 5 issues identified by your staff. So today we're going to talk about the increasing presumptive prison rate, its connection to mitigated departures. And then at the next commission meeting, I believe we are going to have a couple more presentations from our research team on related issues. Okay, so I think everybody has already seen this figure, but it is this was in the 2022 report, but it shows that essentially the presumptive prison rate, which is that kind of dotted brownish red line, has been increasing fairly steadily, really from the conception of the guidelines. And that it has now reached close to 40%. So close to 40% of all cases are recommended to prison by the guidelines. I just want to point out, this isn't the actual prison rate. This is just the percentage of cases that are sentenced that are recommended for prison by the guidelines. And so what we looked at is we focused on the last 21 years, starting with 2001 and ending with, that got cut off, but it's supposed to be 2022. What we found was that the presumptive prison rate has increased by about 10 percentage points in the last 21 years. So instead of 29% of cases being recommended into prison, about 39% of cases are being recommended into prison. And that makes a very large difference because in 2022, there were 16,259 people that were sentenced under the guidelines, which means that 6,341 of those cases were recommended for prison. If the presumptive prison rate was 29%, as it had been in 2001, that number would only be 4,715 cases. So thousands more cases are being recommended into prison. And so what we wanted to do was to break down what makes up the presumptive prison rate over time, right? The presumptive prison rate is really the percentage of cases that end up in this white area of the grid. And this is just the standard grid, but it's true across all 3 of the grids. And what factors push the presumptive sentence into the prison commit area of the grid, into that white area of the grid? There's really only 3. The first one is the criminal history score, and that can push the sentence into presumptive commit if the score is quite high, even if regardless of the offense severity. So if everything else stayed the same within a given year, and what I mean by that, if the average offense severity didn't increase and more cases, mandatory minimums didn't apply to more cases, if the average criminal history score increased, the presumptive prison rate would go up in that year. Similarly, offense severity can cause an increase in offense severity can cause the presumptive prison rate to go up. If everything else stayed the same, but the average case was sentenced kind of higher up on that left-hand sidebar, the presumptive prison rate would go up. Finally, the third factor is the application of mandatory minimums or other policy exceptions. And so mandatory minimums are laws that require judges to impose a minimum sentence. for certain crimes. And in Minnesota, judges can depart from some of those. But even if somebody is even if the guidelines recommend a probation sentence, the application of a mandatory minimum to a certain case, to a certain offense, means that that case is mandated into prison. So if a higher percentage of cases are mandated to prison through mandatory minimums, right, the presumptive prison rate will go up even if everything else stays the same. And so the first thing we wanted to look at is whether the presumptive prison rate is actually increasing across all three grids, right? And what we find is that it is not. So there is an upward trend in both the standard grid and the drug grid. Similarly, and I think interestingly, both have increased by about 10 percentage points. Now, the drug grid, the presumptive prison rate for the drug grid, has increased at a little bit of a steeper rate, and we're starting that in year 2017, which is the year after the drug grid was adopted. It was adopted in 2016. The standard grid also has a very similar upward trend. Most of it seems to be concentrated right around 2017. There's no obvious trend line for the sex offense grid, except for kind of right there in the beginning. So the sex offense grid was adopted, I believe, in 2006. And so we started tracking it in 2007. And there was a pretty steep decrease, but since then it's kind of stayed steady. So one thing we wanted to look at, let me just back up here for 1 second, is whether the introduction of the drug grid caused an artificial spike in the presumptive prison rate of the standard grid. So individuals sentenced on the drug grid tend to be sentenced under lower severity crimes than individuals on the standard grid. And so what may have happened around 2016, right, is that the individuals that were sentenced under lower severity levels were moved off of the standard grid and now being sentenced on this completely other grid. And so it would cause the presumptive prison rate to go up because on the standard grid, the average severity level would go up, right? And so what we did is we looked at, quite simply actually, whether standard offenses that would not have been affected by either the introduction of the sex offense grid or the introduction of the drug offense grid, whether the presumptive prison rate for standard offenses has gone up over time since 2001. And we find that they have. The presumptive prison rate has gone up over time for standard offenses, and the trend is very similar to the drug grid and to the standard grid overall. So this is to say that starting in 2016, there's been an increase in the presumptive prison rate, and it's on the standard grid, and it's not due just to the introduction of the drug grid. So what's causing an increase in the presumptive prison rate for the standard grid? I want to look at these in detail. I want to look at the grids in detail because there's actually a slightly different story across all three. So the first thing you notice is this is the white here is the presumptive prison rate, and it shows that increase that I have already talked about. The one to the right of that, the kind of pinkish figure, shows that offense severity has stayed steady over the last 20 or so years, so there's no spike. What you do see is that a larger portion of cases are being subject to mandatory minimums. So a larger portion of cases are being mandated into prison, with particularly an increase since about 2017, and that's that green figure. And also the average criminal history score is increasing. I think by about the average criminal history score has increased by about 0.5 percentage point over time. This is just for the standard grid. Okay. So what's causing an increase in the presumptive prison rate for the drug grid? A little bit of a different story. The presumptive prison rate is increasing, but both the percentage of people mandated into prison, so that green figure, and the average criminal history score are not increasing. So they're not contributing to that increase in the presumptive prison rate. What is contributing to that increase is offense severity. So on the drug grid, since the introduction in 2016, individuals have been sentenced at higher severity levels over time. The presumptive prison rate on the sex offense grid is not increasing. And that the sex offense grid in general is a little bit of an outlier because, number one, it's a very small percentage of all cases. I believe it's about 6%, but also the presumptive prison rate is already quite high. So it starts off somewhere around 70% in 2007. And I'm just going to go back for 1 second. So, for example, on the drug offense grid, the presumptive prison rate in 2017 is, at about 20%. So we just already have like a very high percentage of cases that are being recommended for prison. So there's probably not, there's less movement. There's less room for movement in an upward direction, at least. And so what you see here is there is a little bit of a decrease in the beginning, but for the most part, that line has stayed steady and the presumptive prison rate has not increased. What you do see is there's a slight increase in the average criminal history score and a slight increase in offense severity, in the average offense severity, but it seems to be counteracted by a smaller percentage of people being mandated into prison. So similar to a higher overall presumptive prison rate for the sex offense grid, you also have a higher overall percentage of cases being mandated into prison. So mandatory minimums are just more common in the sex offense grid, but the percentage of cases has decreased over time from, so from around 38% of all cases to slightly below 20% of all cases. So a quick summary, increase in the overall presumptive prison rate is being driven by both the drug and the standard grid, not the sex offense grid. Within the standard grid, the increase in the presumptive prison rate is being driven mainly by an increase in the criminal history score and less so by the percentage of cases that are mandated into prison by mandatory minimums. Within the drug grid, the increase in the presumptive prison rate is being driven mainly by an increase in the offense severity level. And the average criminal history score is gradually increasing for individuals being sentenced on both the sex offense grid and the standard grid. One of the topics we're going to examine next is why the criminal history score is increasing. A couple of the things we have talked about is whether, for example, that's even necessarily a bad thing, because if we are using felony sentencing more efficiently, if we're diverting people into misdemeanor sentencing, right? Maybe then we're sentencing more serious individuals. And so you would expect the criminal history score to go up. That's probably not the likely explanation, because the felony sentencing rate has actually risen in the last 20 years. So the population has risen and the number of people sentenced to felony under the felony grid has risen, but the rate has risen as well. So per 100,000 people in Minnesota, a higher percentage of them are actually being sentenced for felony offenses. So it's not that we're being more choosy. It could be something as simple as demographics, and Professor Chris Hugan presented on this earlier, but in the Minnesota population, as well as the US population, is aging, which means that the age of the average felony offender is increasing. And this is also occurring, and this is occurring across the US. There's also some evidence that younger cohorts are actually less involved in criminal activity than prior cohorts at that age. So those two factors interacting with each other would cause the average criminal history score to increase. And because projections show that the 65 and over population is actually expected to keep growing in Minnesota over the next 20 years, that trend is probably going to be more pronounced. So some policy implications is that this is an important caveat. The presumptive one potential outcome of an increasing recommended prison rate, right, is that it causes an increase in the actual prison rate. So if more people are being recommended for prison, maybe judges will sentence more people to prison. That's actually not happening. So the presumptive prison rate is increasing, but the actual prison rate has remained steady, and it's actually slightly decreased in the last few years. And so the only way, right, if we're looking at the future, the only way for the percentage of the actual prison sentences to stay steady while the presumptive prison rate is increasing is if mitigated departure rates also continue to increase. And so the next question that we are going to discuss is, what is the relationship between the presumptive prison rate and mitigated departures? And I will hand it over to Matt to discuss. Thanks.
Thanks, Julia. I'm going to share my screen now. Oh, I need to wait.
Let me figure out how to stop sharing.
It looks like mine's up regardless.
Okay, good.
Yeah, that was a great little transition that Julia had there where, well, before I really begin, I should introduce myself to everyone that I haven't met yet. I'm Matthew Helena, hired on back in March as a research analyst intermediate, really to focus on helping out with the comprehensive review. And so Julia and I have gotten to know each other quite well. We get to spend a lot of time together researching some of these big 5 issues that the staff has identified. And so, yeah, this portion of this presentation is really going to focus on, it's going to continue the conversation about presumptive prison rate, but then also take a little bit more of a focus on mitigated dispositional departures specifically and the rate of those. So I've created a little bit of an agenda for this presentation, just to guide the presentation a little bit more. So first, I'm going to introduce the MSG issues of concern this research has addressed, outline specific research questions that guided this research, discuss the findings specific to each research question, and then have time for questions, comments, and conversation. And that time will be for both Julia and my presentation. Julia's set up the idea behind presumptive prison rate already, but I will provide a little bit of a background. And she's also spoken about those 3 real aspects that cause someone to go to prison, but they'll be touched on again as well. So first, I'm going to focus on these first 2 bullet points. And so the 2 big 5 issues of concern relevant to this research is the increasing presumptive prison rate, which we've just spent some time talking about, but then also high mitigated dispositional departure rates. And so to contextualize those in...
Oh, are you going to explain what a dispositional departure is?
Yes,
We have the
yes.
numbers, I just want to make sure.
Yes, I will. Yes, thank you. Yes. So for the context of this research, the presumptive prison rate is the percentage of cases in which a convicted person is recommended to prison by the guidelines, or an exception such as a mandatory minimum. And so I have a little figure here that shows, the sentencing guidelines grid and the cases. I've put an X over all of these shaded cells because those are not the cells we're talking about here. We're talking about the cells that are unshaded. And then also Appendix 1 of the sentencing guidelines and commentary is an appendix that discusses mandatory minimums and some exceptions. So any case where those apply is going to be lumped into this presumptive prison rate conversation. And so just once again, you can see the presumptive prison rate has been increasing since the inception of the guidelines quite significantly. Mitigated dispositional departure rate. This is the percentage of cases in which a sentencing judge pronounced a non-prison sentence, even though the guidelines or a sentencing exception, such as a mandatory minimum, recommended the convicted person to prison. And so I have another figure here that demonstrates this. And so this is a dispositional figure that shows in versus out. So in being recommended to prison and out being sentenced to non-prison. And that's based on, for our guidelines, offense seriousness and criminal history score. So when a mitigated dispositional departure occurs, the presumptive disposition or the recommended disposition is a prison sentence. But the sentence, a judge departs by pronouncing a non-prison sentence. And so anytime I'm talking about mitigated dispositional departure, that's what I mean here. And this is just a figure of the big five issues from the big five issues that were identified. And this shows that not only have mitigated dispositional departures increased since the inception of the guidelines, but they've remained relatively high. And then this brings me to the research questions that are relevant. So the first research question that we're going to tackle here is, what is the relationship between the presumptive prison rate and the mitigated dispositional departure rate for offenses between the time period of 2001 to 2022? And then the second research question is, what is the relationship between mitigated dispositional departure rates and offenses that have a presumptive disposition of prison sentences due to offense severity, criminal history, or a mandatory minimum / policy exception? And that aspect's really bolded and highlighted intentionally because there will be some specific interest in those offenses towards the later parts of the slideshow. Sweet. So on to discussing the findings specific to each research question. To evaluate the research question 1 of what's the relationship between the presumptive prison rate and high mitigated dispositional departure rates, we selected known offenses that have high mitigated dispositional departure rates, and then plotted the presumptive prison rate and mitigated dispositional departure rate for these offenses from that time period. And so we started to do this individually, and here are a couple examples of what we found. I'm going to provide 2 examples. The first one is general theft. And you can see the blue line is the presumptive prison rate, while the yellowish orangish line is the mitigated dispositional departure rate. And really what's important to focus on here is whether as the presumptive prison rate increases, so does the mitigated dispositional departure rate. And we're not too worried about the rate of change there. We're just looking at whether, yes, indeed, it's increasing, that both are increasing at the same time. And so the other example here is felony DWI. Presumptive prison rate is increasing, and so is mitigated dispositional departure rate yet again. So this pattern started to emerge when looking at all like individual offenses. So the idea was then to look at all offenses together and investigate the relationship there. And similarly, the presumptive prison rate increases over time since 2001, and so does the mitigated dispositional departure rate. And we found that this was highly correlated in a positive direction. So that means, it's positively, well, as one's increasing, so is the other. And so the conclusion here is that as the presumptive prison rate increases for all offenses, the mitigated dispositional departure rate increases for all offenses and vice versa. And so another way of thinking about this is, as Julia pointed out, the actual incarceration rate hasn't increased at all. The actual prison rate hasn't increased over time, but the mitigated dispositional departure rate has, as well as the presumptive prison rate. So to maintain that same relatively level curve, that relatively level line of prison rates, the mitigated dispositional departure rates have taken more or less taken accountability for that. Like that judges appear to be departing more dispositionally from the guidelines to maintain a similar incarceration rate over time. Great, that's research question 1. So now moving on to research question 2. And how we're going to look at this question specifically regarding the relationship between mitigated dispositional departure rates and offenses that have presumptive disposition due to offense severity, criminal history, or mandatory minimum / policy exception is really to look at the different sentencing grid zones that Professor Fraze has presented on previously at a previous commission meeting. And so I'm going to provide an overview of these and then extend this research a little bit further too. But here's the three zones. The three zones are high severity, extensive criminal history, and then recommended non-prison sentences. And so let's look at these in a little bit more detail each. So zone 1, high severity, offenders recommended for prison because of the seriousness of their offense without reference to their criminal history, right? So that's on the standard grid, that's all offenses with a severity of 8 or higher. Zone 2 is extensive criminal history. So these are offenders recommended for prison because of their record, their prior record, but for the criminal history, the offender would be in the presumptive non-prison zone. All right, and so that's everything in orange. And so these people are getting sentenced to prison because of their criminal history. And zone 3 is recommended non-prison sentences. So low severity, low history offenders with presumptive non-prison sentences, unless a mandatory prison statute or other special rule applies. And so that last clause is something I really want to focus on here, that unless a mandatory prison statute or other special rule applies, because looking at these zones, we don't have any sort of way of identifying, or I guess not identifying, but categorizing those offenses that are sentenced to prison because of a mandatory minimum. And so the first part of this research question is providing introducing the idea of a fourth zone, which is mandated to prison. And so real quick, just to ground us in what we're talking about here, a mandatory minimum would be a minimum executed sentence duration specified in statute for offenders convicted of certain felony offenses. And so the example I have here is assault in the second degree. And this is really dictated by statute 609-222 and 609-11 and the interaction between these. So assault in the second degree, part of the characteristics of that offense, and correct me if I'm wrong, is that a dangerous weapon must be a part of that offense for it to be classified as an assault too. And 609-11 declares that any offense with a dangerous weapon has a minimum prison duration, depending on what that type of dangerous weapon was. A policy exception, on the other hand, is an exception specified in the Minnesota Sentencing Guidelines and Commentary for offenders convicted of certain felony offenses. And so the example I have here is subsequent felony DWI. And that's in section 2C3D of the guidelines. And so that's something that was decided upon at some point in time by the commission, that after, regardless of your criminal history score, if you commit a second subsequent felony second or more felony DWI, you will be your presumptive disposition is prison. And so back to zone 4. So how zone 4 exactly works then is offenses in zone 4 have a criminal history score and severity level that would place the recommended sentence in zone 3 non-prison sentence. Right, and so I've outlined that area, the blue area specifically. However, the presumptive disposition of zone 4 offenses shifts from non-prison to prison due to a mandatory minimum or a policy exception, right? So here's an example that helps provide a little bit more understanding. Sticking with assault in the second degree, assault in the second degree has a severity of 6, placing 3 of its cells in zone 3 non-prison sentence. However, a mandatory minimum statute exists that shifts all second degree assault offenses that would otherwise fall into zone 3 non-prison sentence to zone 4 mandatory or mandated to prison, right? So these people would otherwise receive a non-prison sentence, but because the mandatory minimum exists, their presumptive sentence is in fact a prison sentence. And so that is the fourth zone, and here are all 3 zones altogether. Great, so going back to the actual research question is, what are the differences in mitigated dispositional departure rates across reasons why your presumptive prison, you would receive a presumptive prison sentence. the methodology we used was to evaluate, to select known offenses, so similar to what I did in, what we did in research question 1. Select known offenses with high mitigated dispositional departure rates, and determine the grid zone that each case within each offense belonged to, right? And so just to hit on that again, I'm going to go back 2 slides, right? Assault in the second degree can have offenses, because of the criminal history score. If the criminal history score is higher than 2, some of these offenses would land in zone 2, and in that case, the mandatory minimum would not apply, right? And so that's why we took this approach of looking at each case within each offense. And so sticking with assault 2, here's a little table that shows our findings of the mitigated dispositional departure rates and the number of cases by zone. The most important aspect here to focus on is which zone we're looking at and the mitigated dispositional departure rate for that zone. And so zone 2, you can see this is extensive criminal history score. So this person would have had a presumptive prison sentence because of their criminal history score. The mitigated dispositional departure rate for these offenses is 24.4% for assault 2, whereas zone 4 mandated to prison sentences is significantly higher at 66.5%. And so similarly to what happened in research question 1, we started to see similar trends within each individual offense that we looked at, and then decided to look at all offenses together. And so you can see in zone 1, for high severity offenses, that would be presumed to go to prison, recommended to go to prison. The mitigated dispositional departure rate is 35.9. Zone 2 extensive criminal history score is around 30%. And mandated to prison is once again significantly higher than both of those at 57.1%. And so the main takeaway of this research and the findings regarding this research question is that judges pronounce mitigated dispositional departure rates at a higher rate for zone 4 mandated to prison offenses than they do for other sentencing zones. And so really how I understand this is, and I apologize if I overstep, and of course, if there's correction that's needed, by all means. But my understanding seems to be taking an approach in the philosophy of just desserts, and that it seems to me that judges in general, or whoever's pronouncing the sentences, they don't feel that mandatory minimums, it doesn't seem like there's as much just desserts reasoning for mandatory minimums to cause a prison sentence. Whereas for a criminal history score, zone 2 offense, right, we've told you multiple times, don't do this again, don't do this again. This is not your first rodeo, right? Your criminal history score is such that you're deserving to be sentenced to prison. And then same with higher severity, right? Your severity is high at such a severity level that there's more deserving reasons for that. Whereas mandatory minimum, it seems to me that these offenses, there seems to be some sort of understanding that these offenses, without a mandatory minimum being present, they wouldn't receive a non-prison sentence, and that might be causing the dispositional departure to provide a non-prison sentence in the end. Great, so that brings us to the end of both Julia and my presentation, and would love to open up the room for questions, comments, and conversation.
Questions from the commission? Or comments? Commissioner Fraze.
Just a clarification.
Can you speak up a little bit? It's really hard for
I'm
them
sorry.
to hear.
So if we're comparing what's called zone 4, which as I understand is a subset of zone 3, now looking at my slides, I see I've kind of said it both ways, but I apologize. In what we're taking in zone 3, which looks like presumptive out, there's a subset of people who are presumptive in, either because of a mandatory minimum or a special rule, and they have high departure rates compared not only to the zone 1 people, but the people in zone 2. And I know, we talked briefly about this a while back.
Mhm.
If you looked at the zone two, some of the people in zone two do have mandatory minimum or special rule, but they
Right.
also have high criminal history. If you took them out, I looked at them separately, because when I looked at this many years ago, the same rule, a mandatory or a special rule, was often not applied if you were below the disposition line. But if you had the same special rule or mandatory minimum, but you were out in zone two because of high criminal history, then that really is presumptive. And judges would say, okay.
Mhm.
So, and is that true, that subset of zone two, or maybe that is what your data shows? Subset of people that, yeah, it may be that there may be mandatory and special rules out in zone two, but if they weren't in zone two, a lot of them wouldn't.
Sure, right, yeah, so we really only looked at those that fell within zone 3. But I think that would be something that would be very worthwhile to look at and to compare across offenses and within
it's
offenses.
Consistent with different ways of describing your summary there, which the judges think, if you're below the line, you're not supposed to go to prison,
Yeah.
unless it's a really aggravated offense.
Mhm.
Even if there's a special rule or mandatory minimum.
Mhm.
So they really take that disposition line seriously.
Mhm.
But if you're out past the disposition line because of your criminal history, then they say, well, then we really do take the mandatory and the special rule seriously.
Mhm. Mhm.
That would be one way of characterizing it.
Certainly, something we did look at was that breaking the mitigated dispositional departure rates by criminal history score within each zone. And at some relative consistency, the lowest criminal history score within each zone tended to have the highest mitigated dispositional departure, right? And so I didn't look at that for within each offense, right? Which I think would be still worthwhile to look at those offenses that did fall into zone 2. Yeah, but I thought that was kind of quantifying a little bit more of the, I guess, criminal history score being a bigger factor rather than a mandatory minimum in terms of the disposition and determination to go to prison.
I think that's what I'm struggling with too here is trying to tease out, like, is it the criminal history score or the fact of the mandatory minimum that's driving behavior more? Because I'd be curious to see what the departure rate is by criminal history score, like you were saying, and kind of like figure out the intersection of those two factors. Because it could just, the explanation could just as easily be, these are low criminal history first-time offenders. And that was a consideration for the judge, the prosecutor, the defense attorney at the time of recommending that sentence.
Right. I think to add to that, Madam Chair, I think that is a little bit of like justification that criminal history score seems to be relied on more than the mandatory minimums regardless, and that mandatory minimums seem to be holding less weight in that decision.
That makes sense.
Yeah.
Commissioner Mueller and then Commissioner Lack.
Yeah, thank you, Madam Chair. I appreciate both these presentations, and I would love to get a copy after, if we can get those out to commission members. Very timely. I've recently been asked by sheriffs and chiefs on, because there's a sort of commentary, in the public of, officers are arresting people and judges are, going with different sentencing. And so they asked, Brian, you're on the Guidelines Commission, what is that? Like, oh my gosh, there's so much data here. I'm just trying to figure this out. And so I know there's no clear answer, but what I appreciate, there's a slide stating that as severity increases, you rephrase this let me go back, but it was as severity increase or as severity increases, so do the mitigational departures.
As presumptive
As-
dispositions.
As the presumptive prison rate, yes.
It's presumptive prison rate.
Yeah.
Okay.
Which seems to be mainly based on what, Julie presented beforehand, seems to be mainly driven by criminal history score rather than severity.
And then you got in the weeds on that and then mandatory. So that's super helpful because, you know, people are looking at me saying, hey, you know,
Yeah.
what's happening out there? I'm like, oh my gosh, I don't know. So this is very helpful. And I agree with the chairs, like digging in further on what is driving that for maybe each criminal history score, because that's a message that I can, you know, push out to my colleagues too. So thank you for your time on this. Both of you appreciate it.
Commissioner Ladd.
Thank you, Madam Chair. And this is probably outside the pale of what was researched, and I just want to make sure I understand, and because I think one of the things that we're trying to draw a correlation here on is how perhaps these mandatory minimums sort of play into sentencing practices and affect the guidelines as they stand, because they stand as obviously as exceptions. But the question that I have is, so I'm going to use your example of the second degree assault, which is severity level 6. And let's say it's not a firearm, let's say it's a knife. So it's 12 months and 1 day mandatory minimum. They've got no criminal history score, so it would be a 21 months sentence under the 0.
Yeah.
But that would convert to a presumed sentence, right? Because of 60911. So sometimes what happens in that realm is someone actually gets the year and a day commitment for the mandatory minimum. They actually go to prison for that because it's less than the 21 months that's in the grid. So that would be a durational departure-ish. So we're not talking about the durational departures as we're talking about mandatory minimums. We're only talking about the dispositional departures. Am I understanding the data on that piece?
That's
correctly?
correct. Yeah,
Okay.
only disposition.
Okay.
Yes, yeah.
There are so many layers to this onion.
Yeah, it's a big onion.
It's a big onion. Other comments, questions? All right. I think that was fascinating. Both of those, I'm really looking forward to thinking about that a little bit more. And then just to call out to commission members, our next meeting is all about getting a little bit more research thrown at us and then thinking about what we want to do with this and where we want to go and what areas we want to focus on. We have a longer meeting scheduled next time to be able to do that. I'm right about that, right? Next time?
Yep, next time will be starting at 9 a.m. Until 4 p.m. So please block off the day of October 10th.
Yeah, so, and we're going to feed you so that when your brains get overloaded, you know, you'll get refueled and then you'll be ready to talk. But anyway, the point being that it really is an opportunity to say, okay, so what? So what do we do with that? And what does that mean we want to focus on policy-wise as we continue forward with the comprehensive review? And I think we have to think about it a little bit based on what you presented today, but this was really, really, really fascinating. Thank you. All right. I think we will move on to our next item, I assume. All right, so the number 8 on our agenda is overview of criminal history and other sentencing policies in Pennsylvania. We have Dr. Matt Kleinman, Executive Director of the Pennsylvania Commission here. As if you haven't had enough rules thrown at you, he's going to tell us a little bit more about another way to do things. Dr. Kleinman.
Thank you so much. Is that being shown now?
Yes, it is. Thanks.
Okay, great. I'd like to thank the staff for inviting me and giving me this opportunity to talk about the experiences in Pennsylvania, but also applaud the commission in Minnesota for undertaking your own comprehensive review. I think my joining you has just highlighted a lot of the challenges that we here in Pennsylvania confronted in working on this, but also some of the current challenges we have even with our own budget shortcomings that started this meeting. So I spoke to Chairman Reitz about this maybe a year or 2 years ago, just about how Pennsylvania structured this and what went on. And I think as Chair Mitchell mentioned, you will see a lot of details here. And my purpose is not to overwhelm you with details, because each of those decisions, as you just did with your own decisions you've been discussing, are really granular, but it's to give you a more of a overall emphasis of what went into the refinement, specifically thinking and focusing on criminal history. just worth mentioning that similar to Minnesota, Pennsylvania was one of the early adopters of sentencing guidelines, adopting theirs in 1982. We're currently on the 8th edition of the guidelines, but many of those earlier editions were quite similar in nature. And of course, over time, the commission itself has been asked to add a number of enhancements, statutory changes, and I think philosophies of sentencing have changed over time as well, thinking about what the purposes of the guidelines are, but specifically what the purposes of the criminal history is in Pennsylvania, with some emphasis on rehabilitation, evidence-based practices as it relates to supervision, brain science related to juvenile adjudications and juvenile offenders, etc. So with that, I wish I had had a few more minutes because I really liked the phrase a minute ago about the big onion, but while Nate was talking earlier, it reminded me about prior record and all these policies being a balance between fairness and complexity. And I think the thing that came to my mind was this idea of a graphic equalizer, or how a music producer would record their music. And each one of those dials has an impact, but at the end of the day, the purpose is to create, of course, quality, high quality music. So I think as you're making each of those adjustments and making an assessment about each of these knobs in this metaphor, it's really important to be thinking about the overall goals and purposes of your comprehensive review. So getting into Pennsylvania's experience, and I'll showcase this later, there was a thought that the enhancements, if you will, of the prior criminal history were too severe. So as been noted during earlier presentations, criminal history will affect both the in-out decision as well as the duration of either state prison, jail, or probation. So if I can figure out how to advance here, hang on. There we go. Just really quick, this is the former structure, which is the 7th edition guidelines, and this actually is the 6th amendment version of that 7th. And similar to Minnesota, we have these offense gravity scores, the severity of the current conviction offense on the vertical axis, and a measure of prior record on the horizontal axis. And I'll delve into those a little bit in a moment about how especially the prior record is calculated. But I want to just point out, it's, as I prepared for this, it's kind of difficult to talk about just prior record without talking about offense gravity score a little bit, because some of the considerations with the guidelines work hand in hand. So I'll just point out to you, which is not highlighted on here, but if you could see OGS 5, prior record score 0, that's a recommendation for the lower limit of the standard range. So we're an indeterminate sentencing system here, where for confinement sentence, there needs to be a recommendation of a minimum and a maximum sentence for confinement. But that cell is essentially saying everything from restorative sanctions up to 9 months in jail as the starting point. And then for aggravated and mitigated in that same row, way out on the right, it's plus or minus 3. So the recommendation here is everything from community service, if you add the aggravated range, to state prison. So there's really no recommendation in that cell for judges. So some of the rethinking, it was about the breadth or the width of the recommendations that are found in the cells, not just the impact of the criminal history that I'll get into in a moment. I also think it's important just to note that in Pennsylvania, the guidelines themselves are advisory in nature. So when judges are free to sentence within the bounds of the statutory maximums, when there's a sentence that's outside of the aggravated and mitigated range, they're required to put the reasons on the record. We're also organized by levels. And as you could see, we have 8 prior record score categories, 0 to 5, and then 2 for prior repeat offending that I'll describe shortly. So how is it calculated? Let's move this box. So as I mentioned, there are 8 categories, and the prior record is this sum of points accrued based on previous convictions or adjudications up to a maximum of 5 points. And something that Nate highlighted earlier, I just thought I would leave this in, that in order for offense to be considered in the prior record score, both the commission of and the conviction for the previous offense must occur before the commission of the current offense. So again, I'm not purposefully trying to draw any specific comparisons, but I want to talk about the methodology and the process we undertook for this comprehensive review, highlighting some of the policies, and certainly we could talk about questions you might have. So when we get to these points, 1 point is assigned for misdemeanor 1 offenses. Then we move to 2 points for things like felony 2 offenses. 3-point offenses will be more serious offenses. And then we have our 4-point offenses, which are what we call typically crimes of violence, things like murder, kidnapping, rape, etc. So as you move up, obviously you get additional points. So those were only for misdemeanor 1s, but in Pennsylvania, we also count other misdemeanors. So to receive 1 point, you have to be convicted of 2 or 3 misdemeanors. Moving up to 3, you get convicted of 7 or more misdemeanors. One thing to note is we have a category of 0, and while we don't have any half points, essentially, if you notice, 1 lower grade misdemeanor doesn't get you into a prior record score category. So some people think of it as a half a point, but you need 2 or 3 misdemeanors to get 1 point under the old system. And why I mention that is when thinking about the restructuring the guidelines, many of the members and feedback we received was to introduce an idea of a true 0 category. Also, some discussion today was just how prior juvenile adjudications are counted. They receive in Pennsylvania the same points as adults, and there is no cap on the number of points that one can receive. So we do have lapsing policies, and we'll get into that as well later. But the juvenile cases that receive less than 4 points may lapse if an offender has a 10-year period of law-abiding behavior. And the law-abiding behavior here does not consider summary offenses or misdemeanor offenses when thinking about juvenile. Again, lots of detail, and my apology for this detail, but just to give you some background of the old system so we can understand the grid, and then I can make some comparisons about the changes. As I also mentioned, we have 2 categories for repeat felons, and I'll just focus on the latter of the 2 because I think it's easy to understand. So it's an offender who has 2 or more previous convictions or adjudication for 4-point offenses. These are those crime of violent offenses, and whose current conviction offense carries an offense gravity score of 9 or more. So these are pretty, very serious felonies as your current conviction, and you had 2 or more crimes of violence. In essence, this is a 3 strikes and you're out type of penalty. There are not a lot of these in practice in Pennsylvania, and I'll get to that in a moment. So I think, as everybody's talked about, this was my earlier slide replaced by the graphic equalizer, but the scoring rules are pretty complicated as it relates to how all this comes together. And so let me just give a few examples of challenges related to the old version of the guidelines. And I think some of this has to do with proportionality and what we're counting as similar when we view these separate policies that were created, maybe in isolation, but with reference to others. And so we don't necessarily need to answer this, but is somebody convicted of 7 prior misdemeanors who would receive 3 points the same as somebody convicted of a prior aggravated assault, attempting serious bodily injury, which is also a 3-point criminal history? Moving on, we could also look at 4 points. So a person who has 4 1-point theft convictions or 4 1-point stalking convictions, is that the same as 1 4-point aggravated assault causing serious bodily injury? For both of these, or these 3 offenders, they would have the same prior criminal history score. Again, these could be adjudications or adult convictions. And then as the scenario I mentioned just a moment ago, this idea of a true zero. So is a person with zero prior convictions, should they be considered the same as a person convicted of one prior misdemeanor offense? So just as a quick descriptive, this is the proportion of individuals using data from 2019 who fall into these the 8 prior record score categories. So you could see the modal category is a prior record score of 0. Almost half of individuals have no prior record. In this case, again, no prior record could include one misdemeanor offense. And then we have a kind of a small step down from 1 going to 4, several more at PRS 5, and then much more rare occurrence of a prior record score of repeat felon, and then very rare for the repeat violent felon each year. So when we have done and engaged with these review of the prior record score, wanted to think about some of the purposes of prior record, and one was for risk or thinking about public safety, and the other is through the lenses of retribution. The commission in Pennsylvania is very lucky that we work with numerous scholars around the country, but also engage, just like you guys, with universities in our Commonwealth. And so we in the past have worked with Carnegie Mellon, and one of their projects was looking at this relationship between the scores and risk. And what they found was essentially that there's very little differentiation in regards to risk for those middle categories of 2, 3, and 4. So later you'll hear me talk about some of the review and hoping that the new guidelines can be constructed in a way that better reflect risk in the use of prior record score. So as we move on then and we think about the idea of culpability or retribution, I think I'll just take a look specifically at the guidelines themselves. So focusing on a sentence that recommends incarceration, and again, this range, just to highlight it, is what we call the standard range sentence. And so the standard range is between 12 and 24 months. And this is the recommendation for the minimum sentence that's imposed. So a standard range sentence would be between 12 and 24 months. So you could imagine a sentence of 24 months as the minimum. We have a statutory rule that the maximum has to be at least double the minimum. So 24 to 48 months of state prison, but this guides the minimum sentence recommendation. And in the far right, of course, is, as I mentioned, the aggravated and mitigated range. But in this case, the standard range is recommending 12 to 24 months for the recommendation of a minimum sentence. If we go out to RFEL, which is our repeat felon, we see we move from a midpoint of 18 months between 12 and 24 to a midpoint of 66 months of between 60 and 72. And that midpoint recommendation is 3.7 times larger. But when we focus on the lower limit of the standard range, so comparing 12 to 60, having a more extensive prior criminal history at this OGS category leads to a recommendation for state prison that's 5 times as long as somebody with a prior record score of 0. So doing a similar focus on OGS 5, we start with restorative sanctions to 9 months. This is the cell I mentioned that doesn't have a lot of guidance for judges sentencing. 9 months here being for Pennsylvania would be a county jail sentence. Oops. And when we move across to RFEL, we see that if we use RS as 0, we get a midpoint of 4.5. We move to 30 months, but we move from a recommendation of, at the lower limit again of the standard range, from restorative sanctions or probation all the way up to state incarceration. So there's huge movement across the grid into, if we thought about again, the levels from level 2, which is our county incarceration or county programming, up to state and county facilities to state incarceration at level 4. So there is a big increase associated with prior record or criminal history in Pennsylvania. So just breaking that out and looking at those specific OGSs again, when there was a recommendation of incarceration at prior record score 0, going and comparing that to when prior record score is the repeat felon category, it goes up to 9 times the duration increase if we look at prior record score 0 compared to prior record score repeat felon for OGS 6. So I think some of the consideration during our comprehensive review was what I would call an outsized impact of the prior record score. And as I mentioned at the beginning, the recommendations as you move across for these lower offense gravity scores, shifting from a recommendation, at least at the lower limit of the standard range for non-confinement sentences, moving to recommendations of confinement. So the other element that was of great consideration, of course, is how does, if there is some component of racial disparities embedded within prior record score. What this figure shows is the proportion of Blacks by prior record score. So the average statewide, or there's in our data, is 27% of our data is Black. So we think of that as our baseline. And if we look at PRS 0, just slightly more than 20, same for 1. So when we go to the higher levels, starting at 4, 5, RFL, and REVOC, there's a higher proportion of Blacks than there is from the average. So I'll discuss this later. We spent a lot of time discussing about mechanisms or ways that the prior record score might be reconsidered to reduce these disparities in the sentencing. I will say that it's quite a challenge, as we know a lot of those decisions that impact prior record occur upstream from, be it from arrests to prosecutorial charging practices, and then of course prior convictions. So how to mitigate this through the rules of prior record score, I'm sure it's possible. One possibility would be to make all prior record score the same, meaning none. But when you have these categories, especially given the higher rates of arrests for people of color and the higher rates of conviction, especially for more serious offenses, we see it's challenging to utilize that graphic equalizer or our soundboard to make adjustments that really rectify the disparities. So our review, rather than being 2 years, started in 2014 and lasted almost 8 years. And I think that the time may not have been right in Pennsylvania when it started for a quick review, but again, circumstances are different between Pennsylvania and Minnesota that make the timeline and the input different, and then also the way the commission works. So we started with a strategic planning work group in 2014, and that work group was 35 criminal justice stakeholders from around the Commonwealth. That group alone met 17 different times, and they provided a lot of the recommendations that ended up being at least the framework for the final set of recommendations, which included expanding the number of OGS categories or offense gravity score that you'll see shortly, an introduction of lapsing policies as a recommendation. The commission then itself internally had a number of subcommittees that worked on issues. At this same time, there was a statewide initiative for justice reinvestment. And this, one of the recommendations from that group was this idea of ensuring or trying to figure out ways that prior record score would be more closely related to risk. But I'm going to focus most of my comments on this academic review panel that I'll mention in a moment. And then of course what the end guidelines are. And the academic review panel was made up of legal scholars and academics from around the country. We originally proposed, I think we were going to meet 2 or 3 times. We ended up meeting 11 times with these individuals, and we focused primarily on criminal history or prior record score with this group of folks. And that group, just one of the things was to think about prior record score beyond retribution. And as I started with considering rehabilitation, use of evidence-based practices, what information could be available to the court prior to sentencing, and the idea, of course, of restorative justice. This would be a good spot to give a quick tip of my hat to some of the work of Robina Institute that helped guide our discussions about criminal enhancements and prior record score. A monograph that Chairwoman Mitchell and Commissioner Fraze and others helped write really gave us a lot of topics and thoughts, and at the time, a way to think about what other states are doing and think, why are they doing that? And is that something we want to consider? So what should the weight of the prior convictions be? How should we consider juvenile adjudications? What should we think about misdemeanors, consecutive versus concurrent sentences, custody status, as you guys have in Minnesota? That's not something we have in our guidelines as a prior criminal record component. Severity premium for similar prior offending. As I mentioned, we have the repeat felony offender and the repeat violent offender categories. And then something we spent a lot of time on, was the issue of lapsing. And I think part of that was because of a lack of lapsing policies for adults, and I would say a pretty restrictive lapsing policy for juveniles. And one of the great things, of course, working with commissions is leveraging research that's done in the extant research world or by other commissions. And I think the work of Professor Al Bloomstein at Carnegie Mellon and others who looked at redemption and the age crime curve with Professor Nagin as well, really informed our thinking about lapsing of old offenses. And we, of course, the term came up quite a bit about stale prior records. So I just want to give a brief overview of some of the work, and I'm really pleased also to see your commission working with researchers and providing data. I'll just note that this review, more so, I would say, on the offense gravity score than on the prior record score, was really driven by data-focused work by the commission staff. The attempt, of course, was to provide descriptive overviews, and then some, of course, the policy choices would be prescriptive. And I think the lapsing just provides an example. We were unable to necessarily tell the commission about recidivism rates if the lapsing policy was 15 years or crime-free for 20 years. Those became prescriptive decisions by the commission through lots of dialogue, but also through recommendations of those working groups. So thinking just briefly about juvenile adjudications, we of course thought how they're counted. We wanted to know how prevalent they are in calculating adult prior record. What's the consequences of including them? Like, as I mentioned, how do other jurisdictions consider these? And then what are implications of alternative methods in these calculations? So a little deeper dive into our policies under the old guidelines. These are offenses that occurred on or after the 14th birthday up to 18 years old. So this is in a juvenile adjudication, so it requires an express finding by the court that they committed a felony or a select group of misdemeanors to be counted. Only the most serious juvenile, and there's my typo, my apologies, adjudication for each prior disposition is counted in the calculation. These get the same points as the adult conviction, and there's no cap on how many can count. And then there was a pretty one policy related to lapsing, and that would be a crime-free period. If the offender is 28 years old or at the time that the offense was committed, and they remain crime-free for a 10-year period on or after their 28th birthday. Also important to note that crimes of violence under the old rules did not lapse. So one of the things we wanted to know are how common are the juvenile records in prior records. So we looked at 5 years of data, roughly 400,000 convictions in Pennsylvania. And out of those, only roughly 25,000 or 6% had their prior record score impacted by juvenile adjudications. So I think our first thing of note was this is not as common as may have been thought. And I think some of what Nate presented earlier also indicated that it's relatively rare. Similar to the earlier slide, Blacks have a higher proportion of juvenile adjudications counting, or Black juvenile adjudications count for a higher proportion for Blacks than for whites, and very rare for juvenile adjudications to count for in the prior adult criminal prior record for females. When there are juvenile adjudications counted in the prior record, so this is just that 5.9%, the 24,000 individuals, these are the points that are counted. So 1 point was roughly a third, 2 points towards the adult prior criminal was for prior records they get 2 points, sorry. And then you could see 3 points, 4 points was rarer. One thing just to highlight that these 4-point offenses or the crimes of violence are extremely rare. So there are only 2,700 have a 4-point offense. So that 4-point prior juvenile adjudication. So that's 2,700 out of the 400,000 individuals we looked at, but it's 11% of the prior record score points come from those 4-point offenses of the 24,000. So this is a point we've already talked about, but those juvenile adjudications could impact you moving from left to right on the prior record score, which could, in this example, 25% of offenders with juvenile adjudications are sentenced at this offense gravity score of 3, which is a misdemeanor 1 typical offense. And the starting point is the standard range for the minimum sentence recommendation is restorative sanctions up to 1 year in jail. And as you go all the way across, it ends up in state incarceration. So the impact of juvenile adjudications could be quite impactful for the individual as you move left to right under the old system. And so we took a look, and what we found was that this is again based on the recommendations, not based on actual sentences, because we wouldn't know the impact, but the recommendations themselves, looking at the minimum sentence recommendation, increased confinement sentences by nearly 20,000 months per year. And for those who have juvenile adjudications in their prior record score, counted for 34% of all incarceration months. So you could see those juvenile adjudications, though they're rare, when they do exist, they have a big impact given the shift in the recommendations as you move across the prior record score categories. It's fine where I am. So I think that the work again of Robina really guided our discussions, and I'll just read the last quote, that a balanced approach might be to include prior juvenile adjudications in their enhancement score, but limit their application. So that was taken to heart by our work groups, by the academic review panel, and then by the commission itself. So I'll get into in a moment the specific rules that went into our changes and some of the impacts, but this is the new matrix. And as I mentioned, One notable thing is the increase in the number of offense gravity score categories. So we went from 14 categories to 38. We have 5 prior record score categories that I'll explain in a moment, and 8 sentencing levels. And I know the font is probably very tiny for people to see, but one noticeable thing is, I'll go to the next slide, my apologies. So we have a little zoom in here of the bottom part of the matrix compared to the old matrix. In the old matrix, as an example, we only had 2 cells that had recommendations of restorative sanctions as the primary recommendation at level 1. Prior record score 0 for OGS 1 and 2. Looking at this new category of A, we could see that there are 9 categories that are recommending restorative sanctions, but with 5 discrete cells having restorative sanction as the primary sentencing recommendation. But as you move up and we look at OGS 8, the range is no longer restorative sanctions to 9 or these really broad ranges. Instead, it's 1 to 4 months. And the other defining element is we wanted to make the levels have a much more discrete recommendation. So there are cells that have mixed recommendations, but we have pretty much pure probation sentences in level B. Level C, as you go across, are these county confinement recommendations. And then because we have much narrower ranges that are not, and providing clearer recommendations, especially on probation, but also on jail and prison recommendations as well. So under the 8th edition guidelines, prior record is determined by identifying the most serious offense for which a person was adjudicated or convicted prior to the commission of the current offense, and then considering the number of previous adjudications or convictions of equal seriousness. The way this is determined is by first identifying what we call prior offense groups or POG groups. This determines the seriousness of previous adjudications and convictions. So, for example, under the old 7th edition, it was quite complicated where we would have to score each offense for which there was a prior conviction or adjudication, figure out their score. And as Nate mentioned, this would be sometimes probation officers having to figure out out-of-state offenses and add those up. Here we could start with the most serious offense, previous adjudication and conviction. So for example, if we were to scan the rap sheet of an individual and we saw that they had a crime of violence, they would fall into POG 3. If we saw that their most serious was a misdemeanor, unless it was designated as a serious crime, they would fall in POG 1. So they're just identifying the most serious of those prior convictions and adjudications. And as I mentioned, the second step then is determining how many of those there are. So once we make that determination, we move between prior record score groups. So as an example, if we were to focus on prior record score 2. So this would be individuals who had 3 or more previous misdemeanors, no more than 2 previous felonies coming from that POG 2 group, and then only 1 previous serious offense coming from the POG 3 group. So the number of convictions or adjudications occurring within that POG group determines the prior record score category. So again, you could have misdemeanors and you could have felonies falling into this prior record score category 2, or 1 serious offense falling into POG 3. From POG 3 putting you into prior record score 2. So it's still a little complicated, but this chart would allow somebody to look at what their determination is of the most serious and make that consideration of where you fall. So in the example of the crimes of violence, our POG group 4, if you had 1 of those at the bottom, you would be in prior record score 3. If you had 2 or more, you fall into prior record score 4. So I'm going to focus first on juvenile adjudications and their counting rules. They're a little bit different than adults, so what count? So POG 4 offenses are on or after age 14, but before age of 16. For POG 2 or 3 or 4, these are offenses that occurred on or after the 16. So when we think about lapsing, so I think just going back a step, sorry, the commission really wrestled with, again, brain development and thinking about culpability for these prior record score or the POG 4 offenses, these crimes of violence. They wanted to consider those even at starting at age 14. But for the other POG groups, for these lower level offenses, they really start at 16 years old. So wanted to, not counting, for example, a misdemeanor that would have occurred when you were 15 years old in the prior record score. And that has been mentioned, and I won't spend too much time on this, but there's different types of lapsing provisions. In our work on juvenile adjudications, we ran through a number of different scenarios using different decay and different gap policies. The decay is just a certain time frame passing, whereas a gap policy requires a period of crime-free behavior. So again, these are all those dials on that board, and I don't want to go spend too much time on them, but at 25 years old, we remove those POG 2 offenses for juvenile adjudication. So that's a decay. Those no longer count for the POG 2 offenses, which were included some of those felonies. Then moving up to the more serious POG groups following 10 years crime-free since the last adjudication or conviction, move from prior adjudications from POG group 3 or POG group 4 only when this age group, again, of 14 to 16. For those over 16 years old, for committing them when they committed that POG group juvenile adjudication of a crime of violence, has to be 15 years for them to lapse. Thinking about adults, as I mentioned earlier, there were no previous lapsing policies. We've now introduced and adopted several policies related to these different POG groups. Following 10 years since the conviction date of the offense, remove the prior conviction for POG 1 offenses, the lowest level. 15-year period of crime-free for POG 2 and 3, and then 25 years for these crime of violence to lapse. And I'll note that there's a distinction here for crime-free, that it has to be for those people who serve time in jail or prison. It's their time after they've been released. So their time in the institution does not count for crime-free periods. This creates a little bit of a data challenge for jurisdictions about release dates, especially for jails, but this is the direction that the commission wanted to go with. I will say, one of the big challenges for us as it relates to thinking about these lapsing policies, as I mentioned, it will be challenging to evaluate how often will a 25-year crime-free period happen for a person who is convicted of a crime of violence and served time in prison 10, 15 years, and then is going to commit another offense. So I'll just imagine that person, their prior crime was done at 18 years old. Maybe they were sentenced to 10 to 20 years in prison, released at their minimum. Now they're 28, needs 25 years between the last when they were released until the commission of a new offense. So they'll be 53 years old when they commit a new offense for that previous prior to not count towards their prior record score. So there are, plausible examples one could envision, but I just don't see some of these policies as being occurring or being applied very often, given the duration of this crime-free period. But the data will inform future adjustments to the guideline, of course. Okay, so doing a quick overview of the new guidelines, I just picked these state confinement ones as a way to look at it in a similar way that we looked at the old guidelines. As I mentioned, one of the perceptions was the impact of the prior record score was too severe in Pennsylvania. So they wanted to reduce the impact of the prior record score. So if we focus on prior record score 0 all the way up to 4, the highest category, we see that lower limit, the minimum recommendation was 84 months at prior record score 0, and it went up to 132 months for prior record score 4, and that ratio is 1.6. So remember earlier I illustrated that it went up to 9. Now we have constrained it to between 2 and 3 as the max, most of them under 2. I think there was a desire to have it be no more than double the prior record score 0. And if I had made a comparison to prior record score 3, which again excludes those crime of violence and the repeat, actually would be essentially the repeat violent crime people is prior record score 4, which is comparable to that earlier REVOC, we would see then these ratios being even lower. So one of the things the commission did was looking at, again, the recommendations between the two systems, the 7th edition and the 8th edition. We wanted to know what the impact analysis, do an impact analysis of how it would affect. This is just looking at state incarceration, and those changes, again, moving from left to right essentially across the grid and reducing the impact of prior record score reduces the amount of recommended months by 27% from 307,000 months to 223,000 months. And it reduces the number of people who would receive or recommended for state prison by 35%. As I mentioned, the impact between whites and blacks, both are in this instance impacted the same. Essentially the months, a slight more reduction for months for blacks, but slightly fewer blacks not receiving state confinement. So all those changes, even with an eye towards reducing disparity, it reduces the absolute amounts, but doesn't necessarily reduce the disparity between the two groups. I think that, again, going back to the monograph, I think really the work that you're doing is very important, and this summarizes why that's important. And a lot of what the work groups and all those different groups I mentioned that when we were doing our comprehensive review, specifically related to prior record score. So by examining and revising their use of criminal history enhancements, guidelines, jurisdictions may find that they can increase public safety through better prediction of risk, reducing racial disproportionality, mediating the aging prisoner population, and reducing the number of prison beds needed. So our website, I encourage those who are interested, and I'll certainly share this presentation for dissemination, and I know that it'll be posted on your website as well. Underneath each of those little themes there includes all the work that we've done, from research to early proposals to summaries, different earlier versions of the guidelines, rationales for changes, and this keeps going down, including all the other groups that I mentioned. And I do want to say that 2 other things about this, which is, of course, the commission met during that lifespan, and I only focused on the working groups, many times, including special policy meetings similar to your upcoming one that were all day. We went on numerous tours around the state for public hearings and public comments on the guidelines, including for the first time in the history of the Pennsylvania Commission on Sentencing, hearing from incarcerated individuals from the state institutions, both women and men's facilities. At the same time, we were also developing parole guidelines and recommitment ranges, but hearing their testimony was very powerful and important for the commission, as well as, of course, hearing from other criminal justice stakeholders on our published policies. And so our review, as I mentioned, was 8 years in duration. I think as hard as this is to believe, we've streamlined and simplified the applications of policies. It'll be a lot easier for folks in the field to score some of this. I think by creating more specific recommendation for judges, that's also a benefit in at least a little bit of certainty for individuals who are about to be sentenced. And one thing I haven't mentioned, and it's something that Director Reitz mentioned earlier in his talk, was the commission is also engaging in a rebuild of our web-based application for individuals in the field, where the guideline recommendations are developed electronically and provided to the courts, and it allows then the sentences to be submitted back to the commission for our own data purposes. That's another project that is we're calling an enterprise project, and we're using some external vendors, and our estimates it will cost between $1 and $2 million for that project, maybe 2 years worth of work or more to rebuild our tool that we're using. So I think there's a lot of similarities from what I've already heard. And my apologies for going really fast through something that is quite complex. I guess I should have ended with that crazy squiggle diagram that there are so many rules. But in essence, I think I'll just summarize by saying that the review is guided by views of the deficiencies of the old guidelines in terms of application or in terms of comporting with modern philosophies around the Commonwealth of Pennsylvania. And then through this rigorous review that I mentioned was both prescriptive and descriptive, heavy reliance on data, the commission was able to come up with a consensus. And for us, it took a long time. And but I think feedback, this was, I'll just also note, I don't think I said, this is, the 8th edition is effective for offenses committed on or after January 1st, 2024. So now that we're moving into the fall, September, we're starting to see courts sentence people using the new guidelines. So we don't have enough data to really assess how this will impact conformity to the guidelines with those narrow ranges, what's going to happen, both from dispositional departures as well as durational departures. But we also excited that an academic has received a National Institute of Justice grant to do a evaluation of both the comprehensive review of the guidelines and the new guidelines. And sadly, that probably will come out too late for Minnesota, but will certainly be informative for other jurisdictions when they start going down the road that you're going down. So with that, let me just see if I can figure out how to stop sharing and open it up to any questions or comments.
Thank you so much, Dr. Kleiman. That was kind of mind-blowing for me because the whole reason that I wanted you and other commissions to present information to our commission was to demonstrate that there are many different ways to address these policy questions, and sort of seeing your old and new provided so many different views into the variation that's possible, and I really appreciate you going through that. That was really excellent. So thank you so much for doing that. Any questions or comments from commission members? You have blown their minds there.
Well, again, you guys know where to find me. I'm happy to provide input, but I would, if the commission has not already, I really would recommend that monograph from Robina as being a starting point or things to consider, because it does highlight all of the different rules from the different states. And it is quite remarkable how different then they might be similar in how they deal with all these different issues. And just when you think there's not a different way to do it, there really is. So with that, thank you for this opportunity. I really enjoyed sitting in on the meeting, but also having the chance to present.
Thank you. Really appreciate it. Okay, so we are actually at the end of time. Do you have anything for your director's update that cannot wait that you would like to share say?
I think everything can wait, except I do want to let you know that I will be sending out the slides that we got today and reiterating the June, or the activity logistics.
And we have asked for in-person attendance at that one, I think.
Yes, that is the request, that we be there in person. I don't know if the chair's decided yet whether that's going to be. So we have since COVID, we've either met virtually, like during COVID, and then right after we went to these hybrid meeting formats. But we the chair may decide that this is an in-person meeting, and there's nothing wrong with that. So there won't be any virtual aspect to it. But that's a decision yet to be made. But definitely in-person attendance is encouraged for commission members, even if the public will or will not be able to participate remotely.
So I really do want in-person attendance for that next meeting for the commission members, because as I said, part of the purpose of that meeting is to facilitate us through. We've heard a lot of information, so where do we want to start and what do we want to really focus on? That's the goal of it, and I could imagine lots of like dots and brainstorming and stuff that happens better in person than online, and we will have Matt helping facilitate that again as well. So that's yes for next month. Commissioner Larkin.
And I support you. I think it's important for all of us to be here in person. But I wonder, will the public still be able to observe even though we cannot remote in?
Well, that's one thing that I think we need to discuss with Matt, whether or not the type of interaction that we'll have is the sort of thing that the public could even meaningfully see remotely. I mean, there are rules that all discussion has to be audible to remote participants, and I'm not really sure if we're going to be able to do that or not. So that's why we may be going to an in-person thing so that members of the public could be here and sort of wander around the room and listen to what's going on or whatever the case may be. But I don't know. We will see.
Will it be here then?
Yes, it's going to be in this room. Just undecided is whether or not the public will be able to attend remotely or will have to come in person.
Okay. Speaking of the public, we cannot adjourn before allowing public to make any comments if they so choose. So could you let's please ask for a call for
Yes.
public comment.
So members of the public, anybody in the room in person, please speak up. But if you're remote, please raise your hand. You should all. I don't see anybody on just a phone. So please press the button on your WebEx application that allows you to raise your hand, and we will unmute you and hear what you have to say. So if you would like to make a comment to the Minnesota Sentencing Guidelines Commission, please raise your hand at this time. And Madam Chair, I'm not seeing any hands raised.
Did you actually unmute?
I haven't unmuted anybody.
Oh, I see what you're saying.
I'm only unmuting those who have
I
raised
got
their
you.
hands.
I got you. Okay. So I'm also not seeing anyone who's indicated a desire to make a public comment. So unless there's any objection, I will adjourn the meeting and we'll see you next month. Thank you.